rise.
Kosovo Specialist Chambers is now in session.
Please be seated. Good morning, everyone. Madam Court Officer, please call the case.
Good morning, Your Honors. This is case KSC BC 2020-06, the Specialist Prosecutor versus Hashim Thaci, Kadri Vaseli, Recep Salimi, and Jakub Krasniqi.
Thank you. I note that Mr. Thaci, Mr. Vaseli, Mr. Salimi, and Mr. Krasniqi are all present in the courtroom. On the agenda today is the opening statement of the defense teams. In accordance with Rule 126, we will start the Thaci defense and continue with the Vaseli defense. Depending on the time, we may also start with the opening of the Salimi defense today, otherwise tomorrow. We anticipate that tomorrow we will hear all the remainder of the Salimi opening and the opening statement of the Krasniqi defense. Same directions and indications given yesterday do, of course, apply to this hearing. Before we start, the panel has received the Vaseli defense submissions regarding an associated exhibit of W04474. It is filing F01414. Considering that this matter pertains to a witness to be called early in the prosecution case, the panel wants to deal with this matter expeditiously. Therefore, we would like the SPO to respond to this filing by tomorrow, Wednesday, 5th of April at 4 p.m. with no reply being entertained. Mr. Howling, or whoever, is that feasible?
It is, Your Honor.
All right, thank you. This concludes that oral, then it is therefore ordered that the SBO to respond to F01414 no later than Wednesday, the 5th of April by 4 p.m. with no reply to be entertained by the panel. This includes the oral order. We will now hear the opening statements from the Vaseli defense. I'm sorry, from the Thaci defense. Yeah, you can do them both. Mr. Kehoe, you may begin. You have 3 hours.
Thank you, Mr. President, Your Honors, Defense Counsel, our respective clients, the SBO, my colleagues across the floor, good morning. I believe, Your Honor, that we have given up to you a PowerPoint presentation which will basically be the script that we'll go through for the course of our discussions. We have given a copy of that to the SPO as well as to Victims Counsel. Your Honor, if I may, just before we move to the script, just very brief comments concerning the SPO's opening statement yesterday. We sat here for almost a little over 4 hours listening to their statement. And the SBO would have you believe that my client, President Thaci, was at the head of some vast criminal enterprise to take over Kosovo. Beginning in early 1998, when the KLA was a fledgling group of volunteers defending their homes and fighting for their existence. And continuing until September 1999, when Hashim Thaci, together with K4, UNMIC, completed the demilitarization of the KLA and set up a multi-ethnic police force. They do so by putting forth documents and attempting them to connect those documents to detention centers located in sparse locations controlled by local people defending their homes and villages. That was their connection to documents and detention centers, and they believe it is tantamount to guilt. What they failed to bring out through the over 4 hours of their opening statement is context. War. What war does in the context of command and control and effective command and control. Counsel for the SPO talked about collaborators being an existential threat. The only existential threat in 1998 and 1999 was the Yugoslav army and the police in conjunction with paramilitaries. They failed to mention command and control operated at a local grassroots basis where loyalties flowed directly to the operative zone commanders. They failed to mention the essential ingredient of command and control, which is the commander, the general commander of the KLA, who was replaced during the Rambouillet conference while President Thaci and Mr. Krasniqi and Azam Sula were in Paris. Local commanders changed the general commander of the KLA without any input from President Thaci, from Azam Sula, who was then the general commander, or anybody else in Rambouillet. There is no discussion about who controlled the power, and that was at a local level. Nor did they put in context the war that started again so viciously in the summer of 1998 and went into September of 1998. And what did that do to the command and control structure of the KLA? That devastating offensive by the Yugoslav army and the military police. Well, I take the words from the SPO's own witness. It destroyed our brigade. People left and went to other countries. And it wasn't just in our zone that this happened, but for every zone in Kosovo. In fact, there was no command and control left after the offensive in the summer of 1998. And that destruction of the command and control aspects of the KLA replicated itself again in March, April of 1999, with the ethnic cleansing campaign again by the Serb forces. The KLA during that period of time was totally dismembered, to the extent that the KLA had recovered from 1998 was virtually eliminated in 1999. What happens to a command and control under these circumstances? What happens to the alleged vertical command and control that the SPO attempted to put before you? It virtually ceases to exist. Yet throughout all of this, the SPO would have you believe there was a functioning command structure with effective control. I submit to your honors, nothing could be further from the truth. What we would like to do at this point, your honors, is begin to put this matter in context, to put the facts of what was happening on the ground in context by beginning with an initial introduction of our client, President Thaci, taking through with you his role throughout all of these years in 1998 and 1999. What we have done is put a roadmap on page 2 and 3 to allow your honors and respective counsel to follow us through so your honors can know exactly what subjects we're going to touch upon and the relevance to these proceedings. I mean, who was Hashim Thaci in 1998 and 1999? Young man, 30 years of age, not to be confused with the man that became the prime minister and the president of Kosovo years later. He had been a student activist that came back to Kosovo in March of 1998, right after the Yashari murders, which of course the Yashari murders being the kicking off point of this alleged joint criminal enterprise. And there was discussions yesterday about motive. And I believe counsel for the SPO talked about motive and that there was no need to examine motive. We submit to your honors motive is a very, very important aspect of this case. Hashim Thaci had no motive to participate in any crimes. As one of the political leaders of the KLA, Hashim Thaci knew that the success of the Kosovo liberation movement depended on the support of Western countries, in particular, the United States. Yes, you can broadcast. I'm sorry. My apologies, Your Honor. I don't think I told the folks to broadcast this. May I proceed? We can move to the next slide. Very early in these proceedings in 1998, the United States offered assistance to the KLA under certain conditions. No attacks on civilians, no actions outside of the territory of Kosovo, no assistance for Islamic fundamentalists or any extremist groups, and no financing for illegal drug trafficking. The conclusion of the CIA in a report to the U.S. House of Representatives noted the UCK, or the KLA, was not involved in terrorist activities designed as premeditated, politically motivated violence perpetrated against non-combatant targets. Next slide. In short, Hashim Thaci and the KLA had no motive to violate the U.S. conditions. Hashim Thaci was well aware that Kosovo could not achieve either independence or self-rule without the assistance of the United States or other Western powers. He had every motivation not to engage in the JCE described in the indictment to not jeopardize U.S. support. Now, crimes were committed, but they were not motivated by the JCE described in the indictment. President Thaci does not deny that crimes were committed by some Albanian individuals during and after the conflict. He informed the UN Security Council of such in a public hearing on the 17th of December, 2018. But he rejects, and the facts militate against the SPO's claim that the crimes were committed as a matter of policy of the leadership of the KLA. He also rejects the SPO's claims that crimes were committed in a widespread and systematic manner on a scale alleged by the SPO. Where did this violence come from? Because there was violence, and we do not argue that there was violence. But the violence was the result of uncontrolled, localized activity, not the product of a JCE. There was revenge and score settling, general lawlessness due to the war and the post-war absence of institutions. And we will get into those issues as we move forward. And the lack of effective control by the general staff over operative zones. Because the KLA was a locally based army, to the extent that it was an army at all. And post-war hatred of the displaced population returning after the war ended had a lot to do with the violence that took place. In short, revenge was a significant motive for violence and crime. Crimes committed by the Serbian regime explain the violence that occurred during the war and following the return of the displaced population. At no point during the SPO's opening was the issue of revenge of the local population during the war as to what happened to them by the Serb regime and thereafter ever discussed. If I can quote for you the comments at the time, this is September 22nd of 1999, these are the comments of Milo Đukanović. Comments that are very significant because when he made them, he was not only the president of Montenegro, but as I know your honors know, this was Serbia and Montenegro. They were part of, they were connected with Serbia. It wasn't just Montenegro alone. And he noted in comments to the Parliamentary Assembly of the Council of Europe, the ordeal that the Serbs, the Montenegrins, and other Albanians are undergoing is the result of the atrocities perpetrated by Serb forces who wreaked havoc during the war in the province and then fled to safe distances, leaving their compatriots to pay for their misdeeds. Revenge by the population was very much a reason for the crimes that took place on the ground. If we can turn to the next video. This is a video from the BBC, and it talks about the expulsion of civilians from Peja in March and April of 1999.
Nuk ishte mundësi që t'ju kundërvyen aleatëve të NATO-s, ata do të na kundërvyen neve përmes dritarëve që po shkonte ty me flakë shumë të mëshëm, sepse e pritja se edhe neve do të na ndodhë e njëjta gjë me Do na e dëbojnë nga shtëpia ose do na kallin në shtëpi. Isha shumë i dëshpëruar.
Valmir and his sister Valentina remembered the threats their Serbian neighbors had issued earlier. Now their neighbors turned on them again.
5 minuta pasi ranë për të fjetur gjithë, filluan disa trokitje në derë, në gjuhën e tij serbe, dhe me njëherë filloi me këto fjalë policia, qelini derën.
Pastaj pas zërit që e dëgjoj e kuptoj se është kushia.
Se të mbyste të gjithë familjen, apo për ndonjë përdhunim tjetër.
That night they were herded with thousands of others into a sports stadium.
Aty s'kishte çka për të parë, ishte, mund të them, ndoshta jo i tash qyteti, por gjysma e qytetit. Deri për ai të pasur, pasi që kishte të smut, kishte bebe, njerëz pleq, plaka, invalid. Por këta ju kthenin me përgjigjen, vetë keni kërkuar kështu, keni kërkuar NATO dhe tash durani.
The next day they were driven on foot from their country, the first trickle of what would soon become a flood of humanity. Valentina thought only of returning and of revenge.
O Zota, ka mëshirë për neve dhe do të vi një ditë dhe t'ju kthejmë dhe na këtyre kështu sikur na përqeshin.
Revenge. The motivation for so much of the violence that took place during and certainly after the war. And the Limai judgment acknowledged that and noted that revenge was a significant motive for crime. In Limai, they expressly found that rogue elements of the KLA had in fact committed crimes against perceived collaborators with the Serbian regime in revenge for crimes that had been committed against Albanians. A number of Kosovo Albanian citizens may have been abducted for other reasons, such as personal revenge of individual KLA members and other motives. The KLA did not have the resources or the command structure to adequately control the implementation of this policy by its forces, and at the time relevant to the indictment, the Chamber accepts that individual cases of abduction for reasons not within the collaborator policy were carried out by rogue elements of the KLA. Now, Your Honors, we have, of course, taken your guidance on not going through all the Serbian crimes. We are not advancing a tu quoque defense, but I believe a brief recitation of the idea of the crimes that took place during the operative time frame, and this list is not meant to be exhaustive, but an examination of some of these incidents during this time frame, I believe, would be instructive. This is during February, March 1998, and thereafter, we have the 5 March 1999 Yashari compound killings, 59 dead, 18 women, 10 children. 23 April 1998, Takan, 20 Albanians dead. In the 6 months, in spring, summer 1998, 300 villages were ravaged with over 250,000 people driven from their homes. These attacks were accompanied by military operations against the KLA by the Yugoslav army and the Serbian police from the spring 1998, increasing intensity until October 1998. That is the offensive for which I referred to from the SPO witness, that their brigades were totally destroyed in the KLA, and they were destroyed all over Kosovo. 26 September 1998, Abria Ebreme, 25 killed. 15 January 1999, Ratchak, 45, 25, 27 March 1999, Krushamada, 241 killed. 28 March 1999, Izbica, somewhere between 146 and 166 Albanians were killed. Rosalia, 41 Albanians killed. And 5 April 1999, 27 April 1999, in Maya, 300 Albanians, 2 May 1999. In Studeme, 100 Albanians killed. And then, of course, the forced expulsion from Kosovo itself of 800,000 Albanians, with another approximately 250 to 300,000 Kosovo Albanians being displaced from their homes during the operative time frame in the winter offensive of 1999. What does this do to the command structure of the KLA? The Serbian violence led to the destruction of the KLA and led to action from the UN Security Council. The brutality and scope of the Serb state acts during the summer of 1998 offensive nearly destroyed the KLA. Soldiers left their units, they left the country, and when a ceasefire came, they attempted to piece the entire entity back together again. What came about as a result of this violence was U.S. Security Council Resolution 1199, which expressed grave concern over the excessive and indiscriminate use of force by Serb forces, demanding that the parties cease hostilities and that the Federal Republic of Yugoslavia order the withdrawal of security units used for civilian repression.
The interpreters kindly note that this is really too fast for a proper interpretation of your opening statement. We will burn out.
I take direction, Your Honor, and unfortunately I have been accused of that before. And I do apologize to the folks in the interpretation booth, and I will slow down. Compliance with the Resolution 1199 rested with the Kosovo Verification Committee created in 1998. However, yet another massacre in Račak in 1999 threatened the KVM mission and led to another onset of hostilities by the Serb forces. We will turn to the video in Račak where 45 were killed.
Homes in the village of Račak were still smoldering on Saturday, a day after Serb forces launched an attack on separatist Kosovo Liberation Army fighters. At first, it appeared that a number of civilians had been caught in the crossfire. But international observers, led by the American William Walker, now say as many as 45 civilians were executed by Serb forces. Surviving villagers say the Serb police separated men from their families on Friday before herding them up a hill where they were shot. All the dead were wearing civilian clothing, among them a young woman, a 12-year-old boy, and many older men, including one aged 70.
Unfortunately, I do not have the words to describe my personal revulsion or that of all who were with me at the sight of what can only be described as an unspeakable atrocity.
These atrocities were followed by other acts, criminal acts by the Serb forces. But it did lead, we can go to the next slide, in an emergency meeting, if I will, of the contact group ministers, which was convened in London on 29 January 1999. The contact group condemned the Račak massacre and summoned the parties to Rambouillet to, quote, stop the spiral of violence that is building towards renewed humanitarian catastrophe and all-out war. Not only was it leading to humanitarian catastrophe and all-out war, it led to the destruction of any conceivable command structure within the KLA. NATO expressed its readiness to take whatever measures necessary if the parties fail to meet the demands of the international community. And so we moved to the Rambouillet Conference in February of 1999. Mr. Thaci had been elected leader of the Albanian delegation, but the fact is that Mr. Thaci, who was living in Switzerland at the time, had no control over the KLA. Hashim Thaci could not sign the Rambouillet agreement without the consent of the zone commanders, and the zone commanders had so much power that they sacked the general commander, Azam Sula, while Hashim Thaci was in Rambouillet. And if I might add, we can go, not only was Hashim Thaci in Rambouillet, so was Azam Sula. So, to lay the scene, Hashim Thaci is in Rambouillet, as is Azam Sula, as in other members of the KLA, including Mr. Krasniqi. At the time, Azam Sula is the general commander of the KLA. And with no input from Hashim Thaci or Azam Sula or anybody part of the KLA delegation, Azam Sula was sacked as commander and replaced by Suleiman Salimi. Now, this is supposed to be a command structure that has effective command and control over all of the detention centers that were outlined by the SPO yesterday. By this act alone, the court unmistakably can conclude that there was no effective command and control structure by Mr. Thaci or anybody else in Rambouillet over the zone commanders in the field. He simply did not have effective control over the KLA, nor the final authority over the politics and policy of the KLA. The evidence from Rambouillet demonstrates that Hashim Thaci did not have the ability to prevent or punish crimes occurring in the zones. And as I noted, although Hashim Thaci was elected leader of the Albanian delegation, the real power remained with the zone commanders. Next slide. I have set forth here, Your Honors, the delegations. There were LDK members, Mr. Rogover, Prime Minister Bukoshi. There were LBD members, and of course there were KLA members and also independents. I highlighted Azam Sula's name there because at that time he was the general commander of the KLA when he got to Rambouillet. Unfortunately, he was not the general commander of the KLA when he left Rambouillet. And that was a decision that was made by none of these KLA representatives in Rambouillet. The vehement opposition to this delegation's attendance and engagement from some KLA factions, including the zone commanders and the Albanian diaspora. As I noted, in the midst of the Rambouillet negotiations, the Azam Sula was removed from his position and replaced by Suleiman Salimi as overall KLA commanders, and these developments were supported publicly by Adam Damaci. Now, we will talk about Adam Damaci and the power that Adam Damaci wielded in the KLA, but I note for the record that after almost 4 hours of discussion yesterday, the name Adam Damaci did not come from the SPO in any context as wielding any power in the KLA. Suffice it to say, this decision on the removal of Azam Sula was made with no consultation with Azam Sula, Hashim Thaci, or anybody else. Yet, we sit yesterday for over 4 hours through a litany of detention centers and command and control arguments and documents without once referencing the fact that the person, the overall commander of the KLA, was removed without any input by the so-called folks who were in Rambouillet and speaking on behalf of the KLA. Who was in command and control of any of these detention centers? I think it's quite clear. It was the people on the local level, the zone commanders and their subordinates. And as far as Hashim Thaci's ability to sign any Rambouillet agreement whatsoever, that was seriously called into question by a variety of factors. The first factor was the need for some type, or the desire for some type of approval by Adam Damaci. Adem Damaci was the KLA general political representative and supreme political authority in the KLA. During the conference in Rambouillet, Hashim Thaci left Rambouillet to travel to Slovenia to seek Damaci's approval and support. U.S. Secretary of State Madeleine Albright called Damaci to support Rambouillet. He categorically denied. Damaci opposed participating and signing the Rambouillet Agreement because it did not include independence for Kosovo. Notwithstanding that, Mr. Thaci went back to Rambouillet to discuss matters with international leaders, who then in turn put pressure on him to sign the Rambouillet Accords, which he ultimately did not. We can turn to the next tape.
The foreign ministers all sat at a long table, as if we were in judgment or something. And first, Thaci was brought in with a couple of other members of the Albanian delegation. The question was basically, do you agree with the framework, yes or no? And we were expecting a yes, or I was. I said, look, I don't understand what just happened in there. You have let us down. It is an impossible situation now. How could you do this? We expected you to be a leader.
Albright ka deklaruar se po që se ju nënshkruani, serbët nuk nënshkruajnë, ne do të bombardojmë. Ne do të aktivizohemi. Po që se serbët e pranojnë, ne kemi duart e lidhura.
You could see that he was just shocked. I mean, he looked like a high school student that I had dressed down.
He looked like a high school student that I had dressed down. This person that the SPO wants to advance as spearheading the efforts of the KLA are described by the Secretary of State as a high school student that she had just dressed down. And there was a reason why he did not want to sign the Rambouillet Accords. Keeping in mind, Your Honors, that if they didn't sign the Rambouillet Accords, NATO would not intervene. If they did sign, they would, and then they would begin their bombing campaign. The stakes were quite high. Yet Hashim Thaci was reluctant to sign the accords, and we will tell you the reason why. We can go to the next tape.
Mrs. Albright was confident Thaci would accept the terms on offer, even though they promised Kosovo only autonomy within Serbia, not the independence the KLA was fighting for. But she didn't realize the pressure the KLA leader was under from home.
We phoned each delegate and warned them. We said, don't dare sign. In Kosovo, there was the opinion that maybe the Albanian delegation is acting in a treason. I remember one of them, I told them, we have anti-aircraft rockets on the Serbs. We'll use them against Serbs. If you sign, we'll say, want to bring down your plane.
An operative zone commander, Namdegur Remy, noted that they signed the Rambouillet Accords, they will take down the plane with a rocket. And these threats did not just come from the zone commanders, and they were not just some imagined threat that Hashim Thaci came up with in Rambouillet. They're reflected in the book of Ambassador Christopher Hill, who is a senior U.S. ambassador in these delegations throughout the Rambouillet Accords in February of 1999. He wrote a book, An Outpost, where he talks about his conversations with Hashim Thaci on this particular issue. If we can go to that slide. Hill asks, why can't you agree to this? I asked Thaci, truly not understanding whether he comprehended the near fatal consequences for the Kosovars of a no answer. It is you who don't understand, he replied. If I agree to this, I will go home and they will kill me. Those threats were echoed by yet another zone commander and then the general commander of the KLA, Suleiman Salimi. He noted in a book, Kosovo, War and Peace, the first time, as I said, we managed through some kind of threat to stop the signing of the Rambouillet Agreement. We threatened them that if they signed something without us knowing, meaning all commanders of the zones, people who carried the burdens of the war, then they would have consequences. Notwithstanding any argument or opening that you heard yesterday, Your Honors, Hashim Thaci did not control the KLA. The zone commanders did. This is a reference to comments by then Senator Biden before the Committee of Foreign Relations of the U.S. Senate. He had had a meeting in July of 1999 with Hashim Thaci, and he made these comments before Foreign Relations on 26 September 1998. And in this, you can see Thaci was trying to advance the position of the KLA in bringing about the end of the war. He notes, "It seems to me bombing worked, and even though Mr. Thaci tells me, as I met with him for several hours, how he did anything, that is, and pardon my comment here, a bunch of crap." And I'm not sure that's a comment that's bandied about the Committee of Foreign Relations often. The incremental impact of the KLA on this process was just that, incremental. No evidence, none. Not surprising, because the KLA had been virtually destroyed during this period of time. You may be talking about 1,500 fighters, not 10,000. Mr. Thaci asked me, he said, "You are 29, like I am, when you took office. Do you have any advice?" I said, "Well, if you're asking, I am happy to tell you, although very different circumstances." He said, "What is your advice?" I said, "Number one, do not take yourself so seriously. And number two, understand, I know that you know you do not control the KLA." Next slide, please. Despite intense pressure, Hashim Thaci would not sign without the approval of zone commanders. Keep in mind, Your Honor, there were two key concessions from the United States that the Kosovo delegation secured. First, within 3 years, the will of the people would be taken into account in a referendum. That assurance was conveyed in a draft letter from the U.S. delegation. Second, the KLA would undertake a transformation process, meaning it would have to transform from an army into a civil force. To continue the pressure on Mr. Thaci to sign, U.S. Secretary of State Albright arranged for a meeting with the Albanian delegation and NATO General Wesley Clark, who at that time was the Supreme Allied Commander for NATO. Despite these concessions and pressure from the international community and the Albanian delegation, because there were others in the Albanian delegation that wanted to sign, Thaci refused to give his final approval until he obtained the consent of the zone commanders. Next slide, please. The Kosovo-Albanian delegation then returned to Kosovo after the Rambouillet Conference to seek approval from the zone commanders and other segments of society. They met with zone commanders and other KLA units to explain the agreement and seek their approval. Several zone commanders were not convinced, but ultimately did not oppose the signing of the Rambouillet Conference because they feared loss of support from the international community, including NATO, and the civilian population was suffering. This was at a time when the KLA was under siege and virtually decimated, and it only got worse. Moreover, they were persuaded by U.S. Secretary of State Albright's letter promising an independent referendum in 3 years, and that the KLA would not be disbanded, but transformed. Ultimately, when they went back to Paris in March of 1999, the 18th of March, and the agreement was signed. Now, if we can turn our attention to the Provisional Government of Kosovo, because comments were made yesterday by the SPO that the Provisional Government of Kosovo came in to fill a vacuum of power, and that the Provisional Government of Kosovo, with Mr. Thaci as the named Prime Minister, was attempting to take control of Kosovo. Nothing is further from the truth, both factually and legally. And let us go back and talk about this power vacuum that the SPO talks about. When did the Provisional Government of Kosovo, or the idea, if you will, of the Provisional Government of Kosovo come up? At the Rambouillet Accords. During the Rambouillet negotiations, U.S. Secretary of State Albright and other European leaders urged that a unified structure be established to speak on behalf of all Kosovo Albanians and to be an implementing partner for the Rambouillet Agreement with OSCE, KVM, and NATO. Keep in mind, Your Honors, at this juncture, there was no discussion of UNMIC. UNMIC had not been created, and in February of 1999, it wasn't even contemplated. The Rambouillet Accords were intended to be an inclusive structure. The Provisional Government of Kosovo was intended to be an inclusive structure, not just comprised of KLA members, but also members of the LDK and the LBD. We have before you the agreement that is in, obviously, Albanian, and the translation in the next slide that is signed by Hashim Thaci for the KLA, Dr. Ibrahim Rugova for the LDK, and for the LBD, Recep Koja. And this was supposed to be a temporary government that was going to be in place until free elections were held, and that the three political groups would have equal representation. So the Provisional Government of Kosovo was not some plan by Hashim Thaci or anybody else in the Kosovo Albanian side to fill some power vacuum to take over the country. To the contrary, even after the Serbs refused to sign the Rambouillet Accords and the LDK pulled out of the the Provisional Government of Kosovo, the United States still wanted a provisional government set up so that the provisional government could work in concert with international entities on the ground. I cite to you a cable by Secretary of State Albright on the 12th of April, 1999. Secretary Albright stressed the need for a broad-based Kosovo provisional government. It was good places had been reserved for the LDK, and it was important to continue to reach out to Rugova. While we could not recognize the provisional government, we would certainly want to work with it in practice. So what is the takeaway from all of this information about the Provisional Government of Kosovo? The Provisional Government of Kosovo was an inclusive implementing partner with the international community. It was intended to be a broad-based government incorporating all Kosovo Albanian political entities. It was not designed to enable the KLA to forcefully take control of Kosovo by targeting opponents and marginalizing other political parties. And it was not designed to fill some quote-unquote power vacuum that has been advanced by the SPO. To the contrary, at the urging of the U.S. and internationals, It was the basic framework upon which international entities would rebuild the civil infrastructure of Kosovo in concert with the international community. Its work began before the war ended, but it began in earnest to work with international entities after the war. With the withdrawal of the Serbian forces and the establishment of UNMIK, and we will get to the UNMIK establishment in a moment, the Provisional Government of Kosovo sought to facilitate the return of refugees and assist in civilian port to municipalities in the country, which would include distribution of food, locating places to live, education, utilities, and other civil functions. The Provisional Government of Kosovo did not have any control over military structures. That was under the authority of KFOR Commander Sir General Mike Jackson and the KLA Commander General Ajim Cheku. And in the post-war arena, the Provisional Government of Kosovo was only one of several governments competing for popular support, including the Rugova Bukoshi Provisional Government and a Serbian office. But let us turn, if we can, for a moment to the 1999 Serb ethnic cleansing campaign and what that did to the command and control structure of the KLA. What that did to the command and control structure of the KLA and all of the matters, or many of the matters that were discussed by the SPO yesterday, where this impact was never addressed. Make no mistake that the plan of the Serb authorities was to ethnically cleanse Kosovo of Kosovo Albanians. We can go to the next tape.
Serbia's parliament duly backed Milosevic's rejection of the Rambouillet terms, as did the Serb public. Serbia's deputy prime minister revealed what Milosevic was planning to do next.
Ako dođe do bombardovanja od strane mi Srbi ćemo prilično stradati, ali Albanaca na
terms, as did the Serb public. Serbia's deputy prime minister
Zamjenik premijera Srbije otkrio je šta Milošević sljedeće namjerava da uradi.
dođe stradati, ali Albanaca na Kosovu neće biti.
The bombing campaign goes forward. We will suffer casualties, but there will be no Kosovo Albanians left. The bombing campaign went from 24 March of 1999 to 9 June. True to the word of Mr. Sheshel, the ethnic cleansing continued during that bombing period. As we noted previously, 800,000 Kosovo Albanians were expelled to other countries, and another 500,000 internally displaced. Homes were burned, IDs seized, farm animals killed, water sources contaminated, women raped. The goal of the Serb campaign was to prevent the Kosovo Albanian population from ever returning to their homes and villages in Kosovo. And the deportation of these individuals was on a massive scale. We turn to the next tape.
On the ground, the chaos that was sweeping the countryside was about to hit the capital. Unhindered by NATO airstrikes, armed police and paramilitaries began to spread terror among the civilian population, looting as they went.
Prema tome nije bilo nikakvih šansi da na prostoru Kosme.
There was no chance that anyone would attack the army from the back in Kosovo. As soon as NATO started attacking civilian targets, there was a mass population movement out of Kosovo. This favored our defensive deployments.
vehicles patrolled the streets, as systematically the civilian population were given a few hours to leave. These pictures were taken secretly by a concealed Albanian photographer.
Mi smo naravno pokušavali da ih odvratimo te ideje.
We tried to dissuade them, and sometimes we succeeded. A great number stayed in Kosovo and were protected by our units.
That was a lie. General Pavkovic's units were in fact organizing the biggest program of forced deportation in Europe since the Second World War. It was bound by the sheer force of the image to evoke memories of Nazi Germany.
We knew that there would have been some effort to retaliate against the population, but what we didn't foresee is that it would be calculated in a way that would have generated a massive refugee outflow.
The scale of it was breathtaking. Milosevic had dramatically raised the stakes.
This entire ethnic cleansing campaign was part of the Milutinovic judgment. If we can go to the next slide, where the court in the, as read by Judge Bonamy, as part of the summary in Milutinovic, noted that the most compelling evidence in support of the allegations that there was a common purpose to modify the ethnic balance in Kosovo in order to ensure continued control by the FRY and Serbian authorities over the province is the evidence establishing a widespread campaign of violence that was directed against Kosovo Albanian population between March and June 1999 and resulting massive displacement of that population. What was the effect on the KLA and the command and control structure of the KLA? In short, the fighting capability of the KLA was crippled as a result of Serbia's ethnic cleansing campaign. Supplies to the KLA were cut off, and of course the morale of KLA members plummeted. Most of the KLA members inside Kosovo left their units for good reason, to accompany their families who had been expelled from their homes and villages. If I might emphasize, Your Honors, that this was a volunteer army of volunteer fighters where people could come and go virtually as they pleased. The Serb offensive destroyed individual KLA units and shattered the KLA's command structure, such that most of the general staff of the KLA left Kosovo. During this entire period of time, virtually the entire general staff was not even in Kosovo. The Serb offensive, the second Serb offensive, not the one in 1998, we're now talking about the massive campaign in 1999, removed any possibility for the KLA to operate as a cohesive unit. That was the impact on the command and control structures of the KLA while these events were transpiring and while you heard so much evidence by the SPO of events taking place on the ground. There was no KLA command structure and certainly no effective command structure. We can just change topics for one moment. We talk a bit about the end of the armed conflict. Next slide, please. After 78 days of bombing, NATO prepared for a ground war, and Milosevic elected to end hostilities in Kosovo. On 3 June 1999, the Serb parliament confirmed the decision to end the armed conflict. On 9 June, Serbia signed the Kumanovo Agreement with KFOR, which provided that all Serb forces would leave Kosovo no later than 20 June 1999. What came into effect the next day was UN Security Council Resolution 1244. The United Nations took over responsibility for maintaining law and order. Their responsibility, as part of a Chapter 7 resolution, was maintaining law and order, including establishing local police forces, and meanwhile, through the deployment of international police personnel in Kosovo, protecting and promoting human rights, ensuring the safe and unimpeded return of all refugees and displaced persons to their homes in Kosovo. With the end of the war, KFOR arrived in Kosovo on 12 June 1998, followed by unmixed civilian personnel the next day, the 13th. On schedule, 20 June 1999, Serb forces withdrew from Kosovo pursuant to the Komanovo Agreement. On the 21st of June, KLA and KFOR signed the undertaking to begin the demilitarization of the KLA. Such undertakings were signed with KFOR with other armed groups such as FARC. FARC was the armed wing of the LDK. At the urging of the U.S., Hashim Thaci signed the undertaking, and after the signing of the undertaking, President Clinton congratulated him for doing so. On 24 June 1999, Serbian parliament lifted the state of war. At that juncture, notwithstanding the protestations and allegations of the SPO, the war was over. It did not extend until September 1999. And what happened with UNMIK when they took over pursuant to UN Security Council Resolution 1244? This was the first time the UN had established an international civil and security presence as was mandated in 1244. The goal to assume full control over judicial, legal, security, and administrative functions. This was not a typical peacekeeping mission. It was unprecedented undertaking in terms of magnitude and complexity. UNMIK was mandated to establish the rule of law and restore Kosovo's institution of self-government. Was it easy? No. To the contrary, it is quite difficult, as reflected by the comments by General Clark to the U.S. Armed Services Committee on 2 February of 2000. The difference between Bosnia and Kosovo is that we are dealing with organized governmental factions in Bosnia. There were police, there were elected officials, there were structures that one could deal with. That hasn't been the mission in Kosovo. There are no governmental structures. There are no local police. There's no shadow communist network, party network, which had kept everybody intimidated there and performed as a shadow government. Instead, there are 1.6 million people who are looking to the United Nations for their total civilian leadership and to KFOR for stability, authority, order, and protection, while civilian structures are created. When UNMIK arrived on the 13th of June, Kosovo was devoid of civil and security institutions. There were no laws, no courts, no municipal structures, no civil society, no municipal services. And what happens in such an environment? In this lawless environment, hundreds of thousands of displaced Kosovo Albanians return to find their homes destroyed, their property taken, and their loved ones missing or dead, and no civil institutions. In short, looking for revenge. Localized individual acts of violence fueled by anger, hatred, and score settling were inevitable and often caused by criminals, rogue elements of the KLA, and people posing as KLA in uniforms purchased on the streets of Pristina and elsewhere. As the International Crisis Group reported in 6th of August, 1999, the KLA denied that there was an organized campaign aimed at creating an ethnically pure Kosovo Albanians. And that was credible because of the revenge motive, and that there was not sufficient proof of an organized campaign. And the Pentagon was well aware of that. This is Ken Bacon speaking on 5 June 1999, shortly before the bombing campaign ended, who commented on what they anticipated was going to happen at the end of the bombing campaign. We can turn to that.
The fact of the matter is that I don't think that Kosovo is going to be a very happy place for Serbs when NATO comes in, and I don't think Serbs will want to stay there. I think they want to return to Serbia. We don't know how big the Serb minority is there. It's probably about 100,000, could be a little more than that. But as Kosovar Albanians flow back in, our assumption is that many Serbs will probably return to Serbia.
It sounds like you're encouraging the Serbs who now live in Kosovo then to leave.
I'm not encouraging them at all. I'm just stating what we anticipate the facts will be.
And General Clark echoed those comments and also talked with a reporter about what the KLA was actually trying to do. And if we can turn to the next tape, this is a tape from 1st of July, 1999.
Margaret Warner has our interview with U.S. Army General Wesley Clark, the Supreme Allied Commander of NATO. She spoke to him earlier this evening.
Welcome, General.
Thank you, Margaret.
I want to talk to you first about the KFOR mission in Kosovo. Secretary of State Albright said yesterday when she was up at the UN, the people of Kosovo are not safe. Is that true?
Well, I think that this is a period of sorting out that's going on. There are hundreds of thousands of people coming back. There have been some terrible things done in that country. There are all kinds of emotions running rampant. And there are Serbs still there, some of whom may have participated in that, others who are just afraid they're going to be taken for guilty because of their ethnicity. There are gypsies who are also being discriminated against. And so there's some legitimate efforts to get property back, there's some revenge taking, there's some score settling. One doesn't really know, but it's a very difficult time. Our troops are there, we're doing everything we can, but of course we're not police.
Do you think if Serbs continue to leave and they don't come back, do you think that in any way undercuts the credibility of what NATO went to war for, this multi-ethnic ideal, as you put it?
Well, I think we have to temper the ideal with reality. And we don't know how widespread Serb popular participation in the atrocities really were. And so maybe a lot of these people helped themselves to their neighbor's property, participated in some masked banditry and worse mischief while the ethnic cleansing was going on. We just don't know. And so some of the people that are leaving may well consider themselves as real targets for international justice as well as for Albanian revenge. So it's a little hard to generalize. But as I said, the ideal is we'd like to promote a multi-ethnic society. And by the way, the KLA leadership has called for the same thing.
And do you think they're genuine?
I think they are.
And the person and the voice at that point calling for a multi-ethnic country in Kosovo was Hashim Thaci. During Mr. Misicic's presentation, Your Honors will get to see during this very volatile time frame the steps that Hashim Thaci was making and speeches he was making to his own people and the international community to bring back and bring about that peaceful reconciliation. Hardly the person who came in to fill a power void, to promote violence so that he and anybody else in the provisional of government of Kosovo could take over. To the contrary, and if we just can touch on a few other items, was that Hashim Thaci supported practical efforts in this post-war arena to control violence and promote ethnic tolerance. When UNMIK first came to Kosovo, following the 13th of June, 1999, the Authority for Public Security in Kosovo arrested solely with UNMIK, not with anybody else, just with UNMIK, pursuant to 1244. Despite having the legal authority, UNMIK could not prevent the violence because it didn't initially have the resources. KFOR had the resources but did not have the training or the desire to undertake police functions. What is clear is that the KLA, next slide please, lacked policing authority. Neither the KLA nor any Kosovo Albanian organization had authority to act as security forces. UNMIC's civil security presence did not step aside and cede government control to any person or entity. One need only look at UNMIC Regulation 1.1. All legislative and executive authority with respect to Kosovo, including the administration of justice, is vested in UNMIC. They had no power to, KLA and the Provisional Government of Kosovo had no power to arrest, had no power to prosecute, had no power to incarcerate. All of that power, that legal power, rested with UNMIC. Notwithstanding that, and knowing that there were problems on the streets of Pristina and the other areas of Kosovo, Hashim Thaci promoted, in the next slide, and supported the Kosovo police force. Now, before we go into this, the argument by the SPO in their pretrial brief and in their indictment is that through this power vacuum that the Provisional Government of Kosovo and Hashim Thaci was somehow boiling up and promoting this violence so that they would be the ones that could fill this power vacuum. One should ask, if you want to promote this type of violence, if you want to promote this type of upheaval, why would you support a police force? Why would you support the demilitarization of the KLA? Why wouldn't you just send the KLA to the mountains of Kosovo where they could live and fight another day? He didn't do that. He didn't do that. Look what he did for the Kosovo police force. In early July 1999, it was very clear, and UNMIC recognized the lack of police enforcement presence in the streets of Kosovo. UNMIC and the OSCE, with the full support of Hashim Thaci, created the Kosovo Police Service, which was designed to train Kosovos of all ethnicities. And keep in mind that Hashim Thaci promoted a police force, a multi-ethnic police force, to serve as police officers and begin handling criminal activity and violence. Training program was accelerated with the recognition that this was an urgent need, and the first class graduated in October of '99. In supporting the police force, Hashim Thaci addressed two civil unrest issues: to get police officers on the street to deal with violence, and to get individual former KLA soldiers employed in reducing the violence. In addition, he worked with KFOR and UNMIC for the demilitarization of the KLA. Is this a step of someone that is bent on taking power and doing so through civil unrest? I suggest to your honors, it is not. As part of the demilitarization process, which had begun on the 20th of June, 1999, the KLA was transformed into the Kosovo Protection Corps, a civil entity. The KLA zone commander's reluctance to demilitarize and was transformed by the personal intervention of General Clark with the commanders. General Clark, in fact, came and convinced them personally to sign on to this agreement. The demilitarization process proceeded to a successful conclusion under the authority of KFOR General Sir General Jackson and the KLA commander Ajim Cheku in coordination with UNMIC and with the support of Hashim Thaci. And the picture we have before you, of course, is Hashim Thaci to the left, Bernard Kouchner from the UN and UNMIC, that's Sir Mike Jackson in the middle, and Ajim Cheku, and of course, General Wesley Clark, signed on September the 21st of 1999. And how did this go? Was this just something that was in writing? Was this just something that wasn't taking place in reality on the stand? General Clark answered that before the U.S. Armed Services Committee on 2 February 2000. Senator Reid asks General Clark, let me ask you with respect to the KLA, are they abiding by their agreement to disarm to your satisfaction? General Clark, yes, they are. Senator Reid, and also in terms of their integration into the new civil service, for want of a better term, of Kosovo, that integration is going peacefully and effectively? General Clark, it is. So here, this man who's supposed to lead this provisional government in violence and unrest to fill this power vacuum is participating and assisting in establishing two crucial institutions to disarm the KLA and to promote civil order on the streets with the establishment of the Kosovo police force. Now let us talk a bit just about the structure of the KLA, because we didn't hear anything about the structure of the KLA except in some documents that the SPO put on the screen yesterday without explaining what actually happened on the ground with the KLA. But let's talk about the KLA beginning in 1998. The KLA was a fledgling guerrilla force made up of local groups of volunteers set to defend their homes. This was not an army. This was people who, to try to repel and throw off the yoke of the Serbian regime, got together as volunteers to protect their villages and homes. Who were these people? These volunteers were farmers, teachers, workers, students, and other civilians from cities, towns, and villages throughout Kosovo and the diaspora. They weren't trained soldiers. They weren't trained military people. They weren't people that had spent time in armies. They were the common man. As a result, units came together at a local level with loyalty to local leaders. And as I noted previously, any developing attempts to organize, those were destroyed in the spring of 1998 by the vastly superior Serbian forces during their summer offensive, which, as I noted, one of the SPO witnesses will tell you that the brigades were destroyed, and those brigades were destroyed all over Kosovo. In November of 1998, as part of the attempted reorganization from the summer offensive that decimated the KLA reconfirmed Azim Sula as the general commander, not Hashim Thaci, reconfirmed Azim Sula, the individual who was replaced in the Rambouillet conference by the zone commanders. In addition, 2 deputy commanders were appointed, neither of whom was Hashim Thaci. Hashim Thaci was named one of the 9 directorates, the political director, or the head of one of the 9 directorates, with no command responsibility over KLA troops in the field. In fact, from approximately 16 November 1998, Hashim Thaci left Kosovo for Western Europe and didn't return to Kosovo until 9 March 1999. So with all of this reorganization and all of this restructuring, what is the end result of the KLA? In light of everything that happened with the summer offensive and the offensive that took place in 1999, which decimated the population, and with the ethnic cleansing calls over 800,000 people to be thrown out of the country. Well, the International Crisis Group had a comment in a 3 March 2000 document noted what happened to the KLA. The highlight, the KLA now is not rigidly structured and never was. And at the bottom, moreover, in terms of a recognizable command structure, the KLA does not exist, and therefore the KLA cannot be blamed for anything. The question has to be, which part of it, which group, which individual? This basic information was reflected in a U.S. Department of State cable on 10 March of 1999, and it talks about the competition or vying for power between the zone commanders and the general staff. It notes, this is March of 1999, after the supposed restructuring, The prospect of the loss of power and influence is the driving force in the opposition to Rambouillet among some military commanders. General Staff political wing officers appear very concerned to maintain KLA unity in the face of the military commander's opposition to Rambouillet. The other major issue has been what the KLA calls its reorganization, but what in fact has been the leadership effort to create an effective general staff with genuine control over the disparate KLA formations scattered about Kosovo. This effort appears to have been only partially successful, as the zone commanders clearly retain considerable operational independence. I'll read that again. The zone commanders clearly retain considerable operation independence. This is of March of 1999. That entire matter is reflected once again in a letter from the New York State Department that was written to the U.S. State Department concerning the KLA command and control. It's from the State Department Assistant Secretary of Legislative Affairs to Mitch McConnell, then the Foreign Operations Committee. The letter is dated 4 May, 1999. 4 May. Just a month before the bombing campaign ends. And in this 4 May 1999 letter, the U.S. State Department tells the United States Senate, Senator Mitch McConnell, moreover, as there is no political structure in Kosovo or effective command and control of the KLA, it would take many months, if not years, to organize them to use and maintain any military assistance the United States would provide. Again, there is no effective command and control of the KLA as of May 1999. What you will find, Your Honors, throughout all of this case and with all of this testimony, the accuracy of the lack of effective command and control in the KLA is beyond any question. There was no effective command and control in the KLA. To the extent there was any attempt to do so, that was destroyed in the first offensive in 1998, and certainly during the ethnic cleansing campaign in 1999. So what was the Hashim Thaçi's role in the political directorate? We saw this organogram, which we will take on, which was, I will submit to Your Honors, completely wrong, the one submitted yesterday. Let us talk a bit about his role in the political directorate. And let us go back, if you will, to Hashim Thaci coming back to Kosovo in March of 1998 after the Yashari massacre. By spring 1998, he was invited to become a member of the newly named General Staff in charge of logistics and media. What did he do? Transported materials and weapons from Albania, like many KLA soldiers did, and many KLA members did. Engaged with media, specifically facilitating interviews for other KLA leaders, and he himself interfaced with diplomats in the field. But how about his command and control responsibilities, especially over the zone commanders? His lack of command responsibility was demonstrated by the Drenica Subzone Command, who issued an arrest warrant for him on 10 July 1998. So he is supposed to be this big power in the KLA and a subzone commander. This is before they was split up into operative zones. The subzone commander issued an arrest warrant for him on 10 July of 1998. His lack of command responsibility in the field is further demonstrated by the decision to unify the KLA and FARC, an agreement that was not signed, but it was, in fact, a proposal that was made. And if we can turn to the next slide. And this is a SPO document, which unfortunately wasn't played for you yesterday. But this is an agreement by members of FARC and the KLA to join forces. So we heard a tremendous amount yesterday about the KLA fighting the LDK and that the LDK were part of the quote-unquote opponents that the KLA was trying to go after. Well, FARC is the military arm of the LDK. They are attempting to join the military arm of the LDK, this is part of these supposed opponents, with the KLA. Importantly, if we look at the individuals that were, first of all, if we look at the individuals that are at the meeting, and this is 2 November 1998, Mr. Thaci is so important, he's not even at the meeting. And look who has to approve this meeting. Adam Damaci, Buhar Bakoshi, the Prime Minister of the LDK, representatives of the KLA, and another representative of the LDK. They do not even mention, he was not perceived, Hashim Thaci was not perceived to be a necessary decision maker. He was not perceived to be a person they had to name in order to bring about this unification of the KLA. And why is that? Quite clearly, in a command and control responsibility for combat operations in the field, Hashim Thaci had no responsibility whatsoever. We turn to the next page. He's listed as one of, Hashim Thaci is listed as one of the members of the government in J1. But look, the power is distributed among FARC members that you see highlighted in yellow. But nevertheless, the import here is who is the person in the KLA who has to approve this? Who is the first person on the list? Can we go back to the other slide? Adam Damaci. Not Hashim Thaci, no one else, Adam Damaci. He was the one who had to agree that the FARC and the KLA unify their forces. And who is this man? We mentioned him previously. He is the general political representative of the KLA from 13 August of 1998 to 2 March of 1999. He's the general political representative, the highest political office of the KLA. During the operative time frame of so much of what the SPO was talking about yesterday, and he's never mentioned in the conversation as the eminent power broker in the KLA, not once. Who was he? And what did he do? He headquartered in Pristina. He had advisors. He held press conferences every week to present the KLA political positions and objectives. He had regular contact with zone commanders, met regularly with representatives of the international community, issued passes to international diplomats and journalists to go to KLA-controlled areas, and mediated the release of KLA detainees. He staunchly opposed the KLA's presence and participation in Rambouillet. A highly respected leader, a person that was the highest political office of the KLA, a person that was revered in Kosovo for having spent so many years in a Serb jail, the person who was presenting KLA's political positions and objectives, and the person that is called upon to approve this agreement for the KLA. And the SPO mentions nothing about him. Nothing about his authority, and then nothing about what steps he took during this operative time frame. Now, if I may, Your Honors, with all due respect, we are moving into the next segment, and if I could turn the floor over to my learned colleague, Mr. Misicic, with the court's permission.
Absolutely, go ahead.
Mr. President, members of the trial panel, good morning. I will pick up here with a discussion of the importance of the distinction between the words policy and politics in this case. Slide 77, please. The role of the political directorate of the General Staff of the KLA was to present the political objectives of the KLA and communicate the political positions of the KLA with domestic and foreign delegations, as well as with local and international media. Amongst other things, the KLA Political Directorate opened KLA liaison offices in Western countries and held press conferences abroad. The Political Directorate was responsible for liaising with European and American authorities and other organizations like KDOM and OSCE. Importantly, the KLA Political Directorate did not set KLA policy, and it did not exercise political control over the KLA. Slide 78, please. The SPO at paragraph 18 of its pretrial brief argues that there was a KLA, quote, policy concerning opponents, and then alleges that it was the KLA Political Directorate which, quote, had responsibility for KLA policy. Slide 79. The SPO in its pretrial brief then implies that an alleged KLA policy to target so-called opponents was created through the General Staff's, quote, policy-making authority, which was allegedly respected by KLA members and which allegedly found itself in KLA rules and regulations as well as in KLA public statements. And yesterday, you were told, and I quote, in his role at the Political Directorate, KLA policy was Thaci's responsibility. Slide 80. The implication is therefore that the alleged policy to target so-called opponents was created by the General Staff, and more specifically, the Political Directorate of the General Staff, and even more specifically, Hashim Thaci. But what evidence has the SPO cited to support its contention that the Political Directorate and Mr. Thaci, quote, had responsibility for KLA policy? All we have is the prosecution pretrial brief. And there it cites to only one piece of evidence, a book written by Mr. Jakub Krasniqi. Slide 81, please. Before we turn to Mr. Krasniqi's book, it is important for the trial panel to understand that the Albanian language makes no distinction between the words policy and politics. In Albanian, both concepts are covered by the same word, politik. But the words have very different consequential meanings in English. In English, politics is defined as exercising or seeking power in the governmental or public affairs of a state, municipality, etc. And in English, policy is defined as a course of action adopted and pursued by a government, ruler, political party, etc. The Political Directorate of the KLA, including Hashim Thaci, publicly presented the KLA's politics. In other words, the KLA's political positions. That's why it was called the Political Directorate and not the Policy Directorate. The Political Directorate's task was to meet and negotiate with international leaders and representatives to secure their support for the cause of Kosovo's freedom. Neither Hashim Thaci nor the Political Directorate were responsible for setting KLA, quote, policy. Slide 82. Now returning to Mr. Krasniqi's 2006 book titled The Major Turning Point, which is the sole piece of evidence cited by the SPO in its pretrial brief to support its allegation that the Political Directorate was responsible for setting KLA policy. Mr. Krasniqi's book was written in Albanian. The SPO submitted an English translation of a short excerpt of that book to support its allegation that the Political Directorate set KLA policy. That excerpt is the following quotation. Hashim Thaci from Buroj, Skenderaj, had pursued his PhD studies in political sciences in Zurich University. He was among the first KLA political leaders and the leader of the student movement in the 1990s, was the head of the political department leading KLA policy. Although sentenced in absentia by the enemy's court, he was continuously present in Kosovo. Slide 83, please. Now, putting aside Mr. Krasniqi's incorrect assertion that Mr. Thaci was continuously present in Kosovo, the key question is whether Mr. Krasniqi actually asserted that Mr. Thaci was the head of the political department and was, quote, leading KLA policy. In the original Albanian text, Mr. Krasniqi wrote that Mr. Thaci directed the politik. The correct translation of politik in this context should have been that Mr. Thaci directed the KLA's politics and not its, quote, policy. But the SPO submitted an incorrect translation to the pretrial judge, who confirmed the indictment on the basis of the inaccurate translation that Mr. Thaci was allegedly responsible for KLA policy. It should not be in dispute any longer that the word politik in Mr. Krasniqi's book should be understood in English to mean that he asserts that Mr. Thaci directed the KLA's politics and not its policy. We know this because in July of 2021, the SPO provided an updated translation of Mr. Krasniqi's book, which now has the correct translation. Quote, Hashim Thaci from Buroj, Skenderaj municipality, who had pursued postgraduate studies in political sciences at Zurich University, one of the first political leaders of the KLA, and the leader of the student movement in the 1990s, headed the political directorate. He directed all the politics of the KLA. Next slide, 84. Again, this is the SPO's own updated translation. Accordingly, there should no longer be any dispute that the SPO incorrectly translated the evidence used to confirm the indictment and in its pretrial brief to allege that the political directorate was in charge of KLA policy, and therefore its allegation that the political directorate was responsible for an alleged policy of targeting civilians. The political directorate and Hashim Thaci were not in charge of the KLA's policies, but rather were tasked with presenting the political positions of the KLA. It should be noted that the SPO provided the correct translation of Mr. Krasniqi's book in July of 2021. Nevertheless, 5 months later, in its pretrial brief of December of 2021, it cited to the earlier incorrect translation to continue to assert that the political directorate was responsible for KLA policy. It then repeated this false allegation against Mr. Thaci yesterday, and the only evidence we know of is what they cited to support the earlier mistranslation. Why the SPO continues to rely on the mistranslation remains unexplained. Slide 85, please. Next, we turn to Hashim Thaci's role in the so-called Provisional Government of Kosovo. Slide 86. Hashim Thaci never had any executive legal authority in his capacity as so-called Prime Minister of the Provisional Government of Kosovo because, as Mr. Kehoe explained, the Provisional Government of Kosovo never came into existence as had been contemplated at Rambouillet, and instead was superseded by UNMIK. Mr. Thaci never had authority over the KLA in his capacity as the so-called Prime Minister of the Provisional Government of Kosovo. While it is true that Mr. Thaci used titles such as Prime Minister in order to present himself to internationals as having more authority than he actually had, he used these titles in name only. As I will explain in a moment, the evidence, or absence of evidence, sufficiently demonstrates this fact. He did as much as he could to promote himself as a person of power and authority, but the reality was that he had no real authority and never had effective control. Soon after the arrival of UNMIK, Mr. Thaci realized that UNMIK had the real power and authority to govern Kosovo and began to cooperate with UNMIK. Slide 87, please. As an aspiring politician with hopes of leading Kosovo, it was in Mr. Thaci's interest to demonstrate to UNMIK that he was a reliable and credible partner. He had no motive to allow or encourage the commission of crimes in Kosovo. Such chaos would only undermine his relevance to international leaders and the local population. To the contrary, he continued to need international support, particularly the support of the United States. Not for personal aspirations, but more importantly, because Kosovo's status had yet to be determined, including Kosovo's ultimate goal of independence. Fomenting violence and lawlessness in the direct presence of UNMIK, international organizations and NGOs, and the world media would have been fatal to Kosovo's independence objectives, and the SPO's allegations to the contrary simply make no sense. Slide 88, please. Hashim Thaci never had authority to investigate and prosecute crimes committed in Kosovo. Such power and responsibility rested with UNMIK. While Mr. Thaci was an influential person and pretended to have power, he had no effective control of the KLA or former KLA persons or people wearing KLA uniforms. The SPO makes much of Mr. Thaci's use of the title of Prime Minister, but what does the evidence actually show in terms of whether a superior-subordinate relationship existed between Mr. Thaci and any KLA perpetrators committing crimes? The prosecution has not cited any credible evidence that Hashim Thaci issued any orders to KLA units or soldiers, whether in his capacity as the so-called Prime Minister of the Provisional Government of Kosovo or as a member of the General Staff or otherwise. And the prosecution has cited no evidence of any reporting line between Mr. Thaci and KLA units or perpetrators. If there are no orders from Mr. Thaci to KLA units and no reporting from KLA units to Mr. Thaci, it is unclear how the SPO thinks it can prove that a superior subordinate relationship existed between Mr. Thaci and KLA perpetrators of crimes. Moreover, it is clear that Mr. Thaci had no material ability to prevent or punish crimes. Slide 89, please. As I mentioned previously, NGOs were on the ground in Kosovo post-conflict and documented the crimes committed in the lawlessness of the immediate post-war period. One such NGO was the International Crisis Group. In its report of the November 2nd, 1999, titled Who's Killing Whom in Kosovo, ICG agreed that there were many people running around Kosovo wearing KLA uniforms, but who were not necessarily part of the KLA. Quote, KLA uniforms and insignia are widely available at shops and kiosks throughout Kosovo and Albania, and after all, anyone can wear a mask. Slide 90. The UN High Commissioner for Human Rights reached a similar conclusion in his report of the 27th of November, 1999, concerning the prevalence of KLA uniforms in Kosovo. Quote, some victims of ethnic violence have reported that their assailants, including men in KLA uniforms, although it is possible that much of the violence is simply the work of criminal elements masquerading in uniforms of the KLA. Open borders have in fact allowed the large-scale arrival of criminal elements, particularly from Albania. It has also been noted that the KLA uniforms are available for about 50 Deutschmarks in Albania, and that Albanian national men with no relationship at all to the KLA can use the uniform as a passport through the German KFOR sector of Kosovo. Slide 91. And to my earlier point about how post-war violence was not in the interest of Kosovo's independence ambitions, and therefore not in Mr. Thaci's interests, we note this corroborating quote from the ICG's November report. It is also generally acknowledged that it is not in the interests of the KLA leadership to be seen sanctioning the increasingly barbaric attacks on Serbs. They are aware of the damaging effect of such assaults, often upon elderly and defenseless civilians, that are rapidly eroding the hard-won sympathy that the Kosovo Albanians enjoy in the West. Slide 92. The ICG report then notes, it is likely credible that Mr. Thaci specifically was unhappy with the crimes being committed. Quote, it is credible that the KLA leader Hashim Thaci, together with many of the KLA's higher command, could be unhappy with the continued assaults and intimidation inflicted on Kosovo's non-Albanian population. KLA leaders have consistently called for Serbs to remain in Kosovo. Thaci said that he was committed to establishing a society of tolerance and that he regretted acts of violence against Serbs and the flight of Serb civilians, saying that, quote, we were committed from the very first day to establishing a society where tolerance and not revenge would rule. We ask all Serbs who left Kosovo to return to help peace and democracy and to respect each other. Since the KLA never had a unified central command, its leadership, even if sincere, can therefore not give complete assurances that KLA soldiers are not responsible for specific acts of violence. Thaci also does not speak for all KLA and former KLA commanders or soldiers, many of whom are known to be vehemently opposed to demilitarization. Slide 93. This is the first video we'll play, and what we'll show you now is in real time the statements Mr. Thaci made in the summer of 1999 concerning the violence. Mr. Thaci repeatedly and publicly called for an end to violence and for the maintenance of Kosovo as a multi-ethnic country where the rights and safety of all citizens would be respected. The following is a video of a public statement issued by Mr. Thaci on the 17th of June, 1999.
I call on Serbs to come back to Kosovo, to those Serbs who fled Kosovo, because we consider that these massacres were not committed by the Serbian people, because we consider that these people can offer a vital contribution for the future and prosperity of Kosovo. And we have worked, we have not waged a war to cleanse Kosovo, but a war so that we are all free and equal.
Slide 94. And 9 days later, on the 26th of June, 1999, Mr. Thaci went to Mitrovica to speak to a large crowd and to diffuse potential ethnic violence.
I am glad we are meeting in Mitrovica today, for which we fought. We have come here today with Mr. Demelo to talk to you and also to talk to the Serb side across the bridge. We crossed the bridge, we went to the hospital, we have sent our people there, They started work, and we are interested in regulating and fixing everything in close cooperation with the international community, and we are going to fix it. As always, we are really interested in solving every problem in a dignified way, with discipline, with culture. We have even waged our war in a cultural way, and so we are going back to premises and build lives with real civic culture, not only Albanian culture, but a democratic culture. We need to understand that Serbs too need to live in Mitrovica, those who have not committed crimes, those who have not killed people. We are not interested, and we do not fuel the fires of a mono-ethnic life. We need to understand that whoever wants to live in Kosovo should live in Kosovo. Kosovo belongs to Kosovars, and they are going to live here.
Go to slide 95, please. A few days later, on the 2nd of July, 1999, Mr. Thaci called for tolerance and ethnic inclusion in a joint statement with other leaders. The first speaker in the video is Mr. Sergio de Mello, the then Special Representative of the Secretary General.
Today, I believe, is the first time that Albanian and Serb leaders of Kosovo meet and talk to one another, establish a dialogue on the most pressing issue of the moment, which is the safety, security, the right to life, the right to property of all inhabitants of this province.
We will stand. We will stand. Could you just sit, please? Well done. I miss it.
We call on all citizens of Kosovo, be them civilians or military, to refrain and influence the others to refrain from undertaking acts of violence against their neighbors, since such acts are unacceptable and those who are responsible for such acts will be brought to justice. We also insist that all the missing people are handed over to UNMIK representatives. We support the joint efforts currently made by activists of Albanian or Serb or other communities, so that, together with UNMIK and other international organizations, to implement these requests. The road to reconciliation will be long and difficult. It is not true that there is an innate hatred amongst people in Kosovo. We need to work together. As first steps, we have agreed today to immediately establish a line of communication between us, UNMIK and KFOR, and holding of joint meetings like this one today. Send out joint messages of reconciliation from TVs and radios. Create a joint crisis force in the region, together with UNMIK and KFOR, which would be able to address urgent problems anywhere, including historic and religious sites, and organize an early meeting between religious and spiritual leaders calling for tolerance.
Miloševićevog režima na Kosovu. Osobe osumnjičene za ratne zločine i zločine protiv čovječnosti će biti izvedene pred lice pravde. Mi podržavamo ulogu...
Both sides condemned the crimes of the Milosevic regime. Persons suspected of war crimes and crimes against humanity shall be brought to justice. We support the role of the International War Crimes Tribunal. Peace can only be built on justice, not revenge.
Sure.
And go to slide 96, please. And 3 days later, on the 6th of July, 1999, Mr. Thaci publicly condemned crimes, including against the Serb population. This is at least the fourth such public statement by Mr. Thaci in the first few weeks after the armed conflict ended.
It is true that recently, especially following the end of the war, and the last few days in particular, we have seen a not very good, decent, or responsible situation by certain individuals or groups who have been involved in breaking into apartments, also abusing the symbols of Kosovo Liberation Army, in lootings, burglaries, burnings, destructions, also in desecrating monuments and busts of Serbs. This is a concerning and worrying phenomenon for us. The Kosovo Provisional Government and myself personally distance ourselves from such irresponsible acts.
If we can go to slide 97. Mr. Thaci's public calls for ethnic tolerance and unity continued throughout the summer and fall of 1999. And we see that in the following video of Mr. Thaci in Rahovec on the 17th of July, 1999.
Your town, as it always known, will also know today to separate the good from the bad, to separate what is even incomprehensible, not respectable at all, or what we have experienced for our orientation, our future. However, the time has come today, as we have always respected new realities created, not to think too much of revenge, of hatred, of divisions. Today is a time of unification, and for this unification, each of us has to play their role, from ordinary citizens to politicians and all the public strata, without any discrimination, political affiliation, ideology, province, religion, or any other affiliation. We should be the ones who, unlike never before, unite for the independence of Kosovo. We do not need an ethnic town. We need to respect all those who want to live in town as free citizens, as law-abiding citizens, citizens who do not think about confrontations, and citizens who did not participate in the massacres committed against our brothers, sisters, and parents. We'll respect all those worthy of respect, but we will also not allow anyone to shield criminals in the town of Rauvec. We are also not going to allow anarchy in town. No anarchy and no spirit of intolerance whatsoever in Kosovo. Because, as we have often shown ourselves, we will show ourselves again that we are the ones who have always respected and who will keep respecting the rules of democratic order. As we respected that in the past, we're going to respect it again in the future.
Next slide, slide 98. On the 21st of July, 1999, the day before the killings of 14 Serbs in the Staro Gracko in Kosovo, Mr. Thaci visited Serb victims of crimes together with a Serbian Orthodox priest, Father Sava, as well as with Mr. Bernard Kushner, the special representative of the Secretary General, and Mr. Momcilo Trajkovic, a Kosovo Serb politician. Next slide, 99. After the killings in Staro Gracko occurred, which Mr. Thaci immediately described to the BBC as, quote, a crazy act designed to wreck the improving relations between Kosovo Albanians and Serbs, Mr. Thaci again held a press conference the very next day to condemn the killings and urge Serbs to remain in Kosovo and not be afraid of Albanians.
This is an act against democracy.
Against the people of Kosovo,
Bashkësisë ndërkombëtare.
international community.
Ky akt I konunon vetëm Miloševićit dhe regjimit të tij.
This act suits only Milosevic and his regime.
Dhe askujt tjetër në Kosovë e botë.
And no one else, whether in Kosovo or in the world.
Ky akt I dhunës ndodhi në ditën kur përfundoi faza 2 e procesit të demilitarizimit të ushtrisë qeverimtare të Kosovës.
This act has occurred exactly in the day when the second phase of the process of demilitarization of the KLA has been completed.
Në këtë rast ftoj edhe një herë serbët të cilët janë në Kosovë që të mos largohen nga Kosova, që të mos kenë frikë nga shqiptarët,
not to leave Kosovo and not to be afraid from Albanians,
të afrohen me njëri tjetrin si qytetarë të barabartë të Kosovës,
to approach each other and to live as equal citizens of Kosovo,
ta ndihmojnë njëri tjetrin, ta respektojnë njëri tjetrin,
to help and to respect each other,
të integrohen me njëri tjetrin,
and to integrate
dhe të ndërtojnë një shoqëri me të vërtetë të mirëfillt qytetare moderne.
in order to live a society of citizens which is up to date with the world.
Next slide, slide 100. And finally, on the 2nd of September 1999, Mr. Thaci met in London with Foreign Secretary Robin Cook to again express his desire for a multi-ethnic Kosovo.
You would like to translate again?
Megjithatë, dukuria negative e largimit të një numri të serbëve nga Kosova ka qenë me të vërtetë një dukuri shqetësuese për ne.
But we have an issue that is causing us great concern, the fact that a lot of Serbians have left Kosovo.
Sepse ne jemi të interesuar që në Kosovë të ndërtojmë një shoqëri multietnike të barabartë për të gjithë qytetarët e Kosovës.
Because we are interested to establish in Kosovo a multi-ethnic society, equal society for all citizens of Kosovo.
Ne ju kemi bërë ftesë dhe I thrasëm përsëri që ata njerëz të kthehen në Kosovë.
And we do ask from all Serbians who left Kosovo to return in Kosovo.
Ta ndihmojnë paqen e demokracinë.
To help peace and democracy. We concluded in the meeting of the Transitional Council yesterday that the situation is improving every day.
Megjithatë ne do të punojmë dhe kam bindje të plotë se në përputhshmëri me ato që kemi nënshkruar ne do të ketë sukses të plot procesi transformimit dhe demilitarizimit të UÇK-s.
But I'm more than sure that we are going to work in accordance with all the agreements that we have already signed, and the process of the transformation and demilitarization of the KLA will be successful.
Sir, can you give us a 100% guarantee?
We have been encouraged that so far the KLA has kept the timetable and has actually surrendered weapons in advance of the dates by which they had to be returned.
Mr. President, I note the time. I have one slide left in this section. I should finish. Thank you. So next slide, 101. All of this video evidence demonstrates that the policy of Mr. Hashim Thaci was exactly the opposite of the policy that the prosecution tries to ascribe to him in the indictment. Mr. Thaci was a smart and pragmatic leader who advocated for law and order in a multi-ethnic Kosovo, both because he personally believed in these ideals and because he knew that this was the only path to Kosovo's ultimate independence. The evidence supports that conclusion. In contrast, the prosecution bears the burden of proving, beyond reasonable doubt, that there is no reasonable explanation of the evidence other than that Mr. Thaci was part of a policy to use violence and criminality to target civilians in order to achieve and maintain power. The SPO cannot plausibly advance that argument in light of the evidence, some of which you have just watched, and in light of numerous decisions of international courts and tribunals that refute the prosecution's case here, and which I will discuss after the break. The prosecution's burden of proof in this case, in our submission, will be insurmountable. For example, let's take a look at this slide. This is from a report prepared by the U.S. Department of State in December of 1999, titled Ethnic Cleansing in Kosovo and Accounting, in which the State Department reported, and I quote, "A July 20 statement condemning attacks on Serbs and Roma was released by the former UCK leadership, and former UCK leader Hashim Thaci publicly denounced the July 23 Grachko attack. There is no evidence that the former UCK leadership is orchestrating the violence. The SPO will have to convince you that the State Department got it wrong, and despite numerous U.S. personnel and assets on the ground, and they will have to convince you that the prosecution has discovered the only reasonable interpretation of the evidence 24 years after the fact, namely their allegation that the KLA leadership generally, and Hashim Thaci specifically, were in fact orchestrating the violence. Mr. President, after the break, I will discuss the prosecution's evidence specifically against Mr. Thaci, as well as the prior international jurisprudence and how it impacts this case.
Do you have an estimate of how long you will continue before ending your portion of the opening statements, or your team's opening statement?
Our plan is I should have about 30 minutes, maybe 40 minutes, and then Mr. Thaci would like 5 minutes.
All right.
Oh, and Mr. Kehoe will have a conclusion as well. I apologize. Yes. But it will be a short conclusion, and then Mr. Thaci. So we should be finished by 12:15.
All right. Thank you very much. You can be seated. We will stand adjourned until 11:30, and please be back at that time.
All rise. All rise.
Be seated.
Thank you, Mr. President. Members of the trial panel, much of the evidence that we presented to you this morning, including in the form of U.S. government cables, statements in the U.S. Senate, reports of NGOs like International Crisis Group, have subsequently had their conclusions corroborated by findings of an international tribunal. And so in addition to the lack of evidence to support its theory, the prosecution's burden is particularly high in this case because many of the SPO allegations have already been rejected by the ICTY. And for the transcript, this is slide 102. The SPO's excuses yesterday in attempting to avoid the importance of these findings are not convincing for reasons I will explain in a moment. Slide 103. But first, we discuss the ICTY findings. In order to prove that the accused in this case are responsible for war crimes committed in the summer of 1999, the prosecution must prove that an armed conflict existed in Kosovo into September of 1999. But the prosecutor of the ICTY concluded that the armed conflict ended in Kosovo in June of 1999, and therefore the ICTY had no jurisdiction to investigate crimes committed in Kosovo after June of 1999. She made these representations to the Security Council of the United Nations on the 24th of November, 2000, and that's on the screen before you. Next slide, slide 104. The same conclusion was reached by Mr. Clint Williamson, the prosecutor of the Special Investigative Task Force set up by the European Union specifically to investigate the allegations in the Marty report. Mr. Williamson is, in effect, the predecessor to the current Specialist Prosecutor's Office. And in a press release dated 29 July 2014, Prosecutor Williamson stated, quote, "The reality is that the ICTY had jurisdiction to address crimes occurring during the period of armed conflict, so up to the point that the war ended in mid-June 1999. Mr. Williamson thus publicly expressed his conclusion that the armed conflict in Kosovo ended in mid-June 1999. But the SPO evidently thinks it discovered some evidence between Mr. Williamson's statement in July of 2014 and the time it filed its indictment in April of 2020, evidence that so convincingly proves the existence of an armed conflict in Kosovo after June of 1999 that you as the trial panel will be compelled to conclude that there is no reasonable interpretation of the evidence other than that an armed conflict existed after June 1999, despite the contrary findings of 2 international prosecutors. Slide 105. 6 of the 10 counts of the indictment filed by the prosecution in this case charge crimes against humanity. To prove these 6 counts, the prosecution is going to have to prove that a widespread or systematic attack against the civilian population occurred during the indictment period. If it cannot prove that such an attack existed against the civilian population, those 6 counts of the indictment must be rejected, and you must acquit the accused of those counts. The ICTY in the Limai case concluded that there was no widespread or systematic attack against the civilian population. But they are worth repeating in the context of the discussion about crimes against humanity. There's no in paragraphs 210 to 217, the findings were that there was no widespread or systematic attack against the civilian population, whether Serbian or Albanian, no policy to target civilians. The policy was to target collaborators with the Serbian regime that was linked to the KLA's military objectives. Individual cases of abduction were carried out by rogue elements not acting within the policy, and any abductions were carried out outside of the central KLA control because of limited effective control. In paragraph 228 of the judgment, says there was no policy to attack the civilian population, but a limited policy directed at those collaborating with the Serbian regime, and this policy was linked to military objectives, as established earlier in the judgment. That last finding in paragraph 228 is additionally notable because it recognizes that there were indeed collaborators with the Serbian regime, something which the prosecution yesterday did not acknowledge a single time. Slide 106. It will also not surprise you to hear that the issue of KLA communiques has previously been litigated before international courts and tribunals, which have rejected previous attempts by prosecutors to ascribe criminal motives to the issuance of such communiques. For example, at the ICTY, the Limai trial chamber concluded that the KLA issued communiques for propaganda purposes and also to target, quote, only those who were believed to have or suspected of having links with the Serbian regime. It made the express finding that this policy was, quote, linked to the KLA's military objectives. And this is all at paragraphs 216 and 217 of the Limai trial judgment, which are on the slide before you now. At paragraph 216, the Limai trial chamber addressed the issue of KLA communiques. Quote, and this is the highlighted portion, the chamber accepts that communiques were intended partly for propaganda purposes. However, there was a KLA policy linked to its military objectives to target those individuals thought to be collaborating with the Serbian forces. Nevertheless, in the guise of giving effect to this policy, a number of Kosovo Albanian civilians may have been abducted or for other reasons, such as personal revenge of individual KLA members and other motives. The KLA did not have the resources or the command structure to adequately control the implementation of this policy by its forces at the time relevant to the indictment, and the chamber accepts that individual cases of abduction for reasons not within the collaborator policy were carried out by rogue elements of the KLA. I also note that the prosecution yesterday argued that after the conflict, the accused tried to justify the communiques as propaganda, and you were told yesterday that this was, quote, plainly false. As this slide shows, the prosecution is not arguing that the accused are plainly false. It is arguing that the ICTY was plainly false. And it is essentially asking you to enter a contrary finding. You will not hear any new sufficiently compelling evidence from the SPO in this trial that will lead you to any conclusion different from the one reached by the ICTY in the Limai case. Slide 107, please. The ICTY in the Haradinaj trials also did not find the existence of a JCE to target collaborators. The 2012 Haradinaj trial judgment rejected prosecution allegations of a JCE to target collaborators, found that there was no widespread or systematic attack against the civilian population. There was no plan to consolidate the total control of the KLA over the Dukajin operational zone through the mistreatment of civilians. And, quote, victims were singled out for reasons that pertain to them individually, a finding which contradicts the SPO's allegation here that a civilian population as such was targeted. Slide 108. To circumvent the findings of the ICTY, and in order to try to fit a square peg into a round hole, the prosecution in this case has tried to redefine the elements of crimes against humanity. So instead of alleging that there was a widespread or systematic attack against a civilian population, they have charged that there was a widespread or systematic attack against a, quote, civilian population of opponents. This approach marginalizes international humanitarian law with unforeseen consequences for future cases. The Limai trial chamber found that the number of victims of crimes was relatively small when compared to the overall population, and therefore the trial chamber could not find that the civilian population as such was the subject of attack. Here, the prosecution has tried to build a case by increasing the total number of victims while simultaneously decreasing the definition of civilian population. In effect, increasing the numerator of the fraction while decreasing the denominator in order to make it appear that a substantial portion of an overall smaller civilian population was targeted. However, the SPO cites no authority for its novel attempt to redefine the term civilian population and thus to reduce the denominator. Just as importantly, the evidence at trial will show that the prosecution in this case will not be able to substantially increase the numerator either. While the number of victims in the Limai case that were allegedly abducted by KLA forces was up to 140, and that number can be found at paragraph 209 of the Limai trial judgment. The total number of such victims alleged by the prosecution in this case appears to be no more than 440, taking the prosecution's case at its highest. This number does not materially impact the conclusions of the Limai trial chamber that there was no attack against the civilian population as such. Finally, let me note the additional novelty that the prosecution is pursuing here. The zone commanders in Limai and Haradinai were acquitted in part on the basis that there was no JCE in their zones and no crimes against humanity in their zones. But the SPO is now charging the alleged superiors of these acquitted zone commanders for participation in a JCE with those same acquitted zone commanders for crimes against humanity in their zones based on materially the same evidence, even though the ICTY rejected those allegations. We submit to you that charging alleged superiors for the actions of alleged subordinates who have already been acquitted for those actions cannot be right. How the accused could have implemented a JCE through acquitted zone commanders is unexplained by the SPO. Slide 109. The KLA did not have a policy to target opponents. Slide 110. Again, the Limai trial chamber explicitly concluded, quote, "The evidence does not establish or even indicate a general policy of targeting civilians as such, whether Serbian or Kosovo Albanian." Slide 111. And I've already showed you the Limai trial chamber's finding that any abuses by KLA forces were outside of KLA policy, and moreover, that the KLA did not have the resources or command structure to adequately control its forces. That is paragraph 216 of the Limai trial judgment. And as an aside here, let me again note that the KLA's use of forces that it could not necessarily effectively control was legally justified for many reasons, including but not limited to matters the Thaci defense has properly noticed to the court, including military necessity and self-defense against the Serbian military campaign and crimes that Mr. Kehoe has already described to you. Slide 112. Accordingly, the SPO must now argue that every international institution that has looked at these issues over the last 24 years has gotten it wrong in many material respects. Despite ICTY findings and Mr. Williamson's findings, the SPO now argues a JCE to target collaborators and opponents existed. The KLA engaged in widespread or systematic attacks. Those attacks were directed against the civilian population of opponents, and an armed conflict existed after June of 1999 into September of 1999. The SPO, 21 years after the fact, implies that the ICTY got it wrong, as did the SPO's predecessor, the SITF prosecutor, Mr. Williamson. They will have to prove to you that the ICTY and Mr. Williamson were wrong in their reasoning, or that the SPO has discovered new, compelling evidence that was both unavailable to the ICTY or Mr. Williamson, or both. This is a huge mountain to climb for the prosecution in this case. The SPO yesterday recognized that it has a problem known as the ICTY problem in this case. And it tried to circumvent that problem by advancing two primary arguments. You were essentially told you should forget the ICTY findings because, first, the prosecution argued that, quote, "No prior court has been called upon to consider the role and responsibility of key members of the general staff in the manner in which the trial panel will be required to do so." First, that is misleading. As I've just shown you, the Limai trial chamber, in fact, did conclude that the KLA did not have the command structure to control implementation of a policy to detain collaborators in pursuit of military objectives. Second, with respect to the point made that you will be the first trial panel assessing the responsibility of the general staff, The question they left unanswered is, why are you the first trial panel looking at this issue? You are the first trial panel looking at this issue because no prior prosecutor thought that there was sufficient evidence to indict anyone on the general staff for crimes that were committed in 1998 and 1999. They reviewed the evidence and found it insufficient to indict. 15 years later, the SPO has indicted on the basis of essentially the same evidence. Now, the SPO tries to distinguish its prosecution from the ICTY cases by relying on documents seized from Mr. Salimi and Mr. Krasniqi. But the SPO did not have those documents when it filed charges in this case. It filed an indictment on essentially the same evidence that the ICTY OTP found insufficient. The SPO yesterday also argued that, quote, no prior court had the fullness of evidence at its disposal which the trial panel will have. But what evidence specifically has the SPO uncovered that is so significant that it will require you to overturn the findings of the ICTY trial and appeals panel chambers that I have just taken you through? The SPO, of course, did not specifically identify any such evidence yesterday. Members of the trial panel, at the end of the prosecution's case, we will ask you, did the ICTY and Mr. Williamson get it wrong? Or instead, did the SPO get it wrong as a consequence of an overzealousness to pursue Mr. Thachi? Slide 113. Next, we turn to the reliability and sufficiency of the prosecution evidence. We will not use opening statements to reveal now all of the holes in the credibility of the prosecution evidence. As this experienced trial panel is aware, there is significant forensic value in witnesses being confronted with impeachment evidence for the very first time when they are under cross-examination. Members of the trial panel, rest assured that the defense will be producing significant impeachment evidence throughout the course of the prosecution's case as they bring their witnesses forward. For now, we will highlight only a few examples for you of just how deficient the prosecution's investigation of this case has been. Slide 114. The first example is the case of the so-called two Serb journalists. Paragraph 113 of the indictment alleges that two Serb journalists were detained and questioned by Hashim Thaci and Fatmir Limaj. They were allegedly threatened and beaten, and the indictment notes that the case, quote, attracted the attention of international representatives. And indeed, human rights organizations issued public statements in relation to the alleged abductions of these so-called journalists. The following slides are not to be shown in the public. Slide 115. The SPO has identified two alleged journalists. Putting aside for the moment the allegation that Mr. Thachi in any way was involved in the detention of these individuals, whether through questioning of them or otherwise, which is expressly denied by Mr. Thachi, what did the SPO do to verify the status of these two individuals and confirm that they were indeed journalists and, more importantly, civilians? Next slide, slide 116. The person whom I will refer to as SPO Journalist 1 was in fact not simply a journalist. He was suspected by Serbian leaders of being a Serb war criminal in the war in Croatia and of also being a combatant in the war in Bosnia. The evidence will also establish that SPO Journalist 1 posed as a photojournalist using media credentials, but was actually a radical nationalist and a combatant in both the Serbian and Croatian wars. What you see on the screen in front of you is a document of the State Security Service of the Ministry of the Interior of the so-called Republika Srpska Krajina, the Serb parastate that existed on the territory of Croatia from 1991 to 1995. In this document, the State Security Service identified SPO Journalist 1 as having come to Croatia in October 1991, quote, with a group of volunteers from Serbia and Bosnia and Herzegovina, close quote. The report says he, quote, claimed to be a newspaper photographer from a media organization and had a certified newspaper identification card. However, he expressed his wish to join the units of the Bankovac Territorial Defense as a volunteer. The report goes on, quote, the group of volunteers gathered around SPO Journalist 1 gained the reputation of criminals for a short time. Criminals who were abusing their participation in battles to carry out robberies and often even murders. It goes on. Due to criminal activities and murders committed, especially in actions near Škabrnja, where they killed tens of civilians, it was decided that this unit be closed down, close quote. For those that are not aware, the reference to the murder of civilians in Škabrnja is a reference to one of the worst atrocities in the Croatian War, for which Milan Martic was ultimately convicted through JCE liability by the ICTY. And this report states that the direct perpetrator of this crime, among others, was SPO Journalist 1, the man who is being presented to you as nothing more than a journalist who happened to be in Kosovo in October 1998. What's also important about this document is that it comes to us from the archives of the ICTY as prosecution evidence used to convict Milan Martic. And I will get back to this point in a moment. Slide 117. We also obtained from the ICTY archives this witness statement of an ICTY prosecution intelligence analyst whose name is on the slide before you now. The ICTY prosecution analyst testified that SPO Journalist 1 was a, quote, hardcore Chetnik, and noted that his combat activities were not limited to the war in Croatia, but also that he reappeared in the region in March 1992, trying to arrange arms supplies to the Serbs in Bosnia. Slide 118. Members of the trial panel, the prosecution, like you, is learning for the first time this morning who SPO Journalist 1 really was. Until this moment, the prosecution has not known that one of its so-called two Serbian journalists was a suspected war criminal and a combatant in the Croatian and Bosnian wars. We know this because the documents we just showed you were not produced to us by the SPO, and they would have had to disclose them to us as exculpatory material if they had it in their possession. The fact that it has not been produced to us leads us to the conclusion that the SPO is not aware of the true background of SPO Journalist 1. And the prosecution's ignorance of his background is troubling because it is an example of how the prosecution in this case has failed to take the most basic of investigative steps to objectively establish the facts. The two documents we just showed you are in the public domain. We went to the online ICTY evidentiary database and typed in the name of SPO Journalist 1. And these documents were available to us in a matter of seconds. How many more of the prosecution's alleged victims has the prosecution not done a basic background check on? The prosecution here evidently did not run the name through the ICTY database to do a basic investigation of who he really was. We, on the other hand, can tell you already that there are other names that they have never bothered to check either. Some were even mentioned in the SPO opening statement yesterday. But more on that during trial and in cross-examination. Members of the trial panel, the prosecution bears the burden of proving the civilian status of each and every one of the persons they claim to have been a civilian victim of crimes charged in the indictment. The case of the Serbian, quote, journalist, close quote, shows that they have not even begun to investigate the status of its alleged victims, and the trial is now underway. The following slide can be shown in public. Slide 119. Next, we turn to the prosecution's allegation in paragraphs 110 and 111 of the indictment that on or about the 20th of September 1998, 13 parliamentarians were detained in Chires. They were then allegedly taken to a school in Banjica and subjected to allegedly, quote, severe beatings and psychological abuse, close quote, over 2 days. Then, after these delegation members had been, quote, badly beaten and had visible injuries, close quote, they were allegedly questioned by Hashim Thaci, amongst others. This allegation was repeated yesterday in the prosecution's opening statement. But is it true? Slide 120, please. Were the parliamentarians allegedly severely beaten with visible injuries? The defense will have much to say in the cross-examination of witnesses about the events at Chires and Banjica. You will hear evidence of the security concerns created by this delegation. But we can already show you contemporaneous evidence of the condition of these parliamentarians within 24 hours of their release on the 23rd of September 1998. You can hear from the parliamentarians themselves on this video and judge whether they appear to have been severely beaten with visible injuries. You can also hear their own contemporaneous accounts of whether they had been mistreated while detained. And, sorry, next slide, please. The video we are about to show you is from a TV show in Kosovo that was broadcast on the 21st of October, 2020, within which the video of the press conference of the parliamentarians of the 23rd of September, 1998 is shown. That is why you see the date of the 21st of October, 2020 on the video, but what is relevant for our purposes is the video you will see now, which was taken on the 23rd of September, 1998.
Pra bëhet fjalë për një konferencë që ka mbajtur zoti Gjergj Dedaj.
This is a conference that was held by Mr. Gjergj Dedaj upon his return from Drenica, which was widely commented and which I believe will be commented even more. So let us see this material and then we'll get back to the studio to listen to the story of Mr. Dedaj about what happened there. Once we arrived in Chires, after we traveled the road passing through several villages and after we were stopped several times in Serb police checkpoints, sometimes for an hour and a half, a unit of secret police arrived, as they say, of Kosovo Liberation Army, who wanted to know who the organizer was, who the group leader was, who the persons there were. I said we were 30 participants from Pristina, members of the delegation, including journalists as well. They also had separate conversations with us. They mainly wanted to know about our political activity, activities of each of us, and I'm referring to a conversation they had with me, my political activity, in my capacity as the deputy head of the parliament and as the leader of the Kosovo Liberal Party. The method, we were stopped, we were detained, for me personally was incomprehensible, unnecessary, because we were not unknown people to the public. Our activity has always been legal. We will always give it priority. Yesterday, after a very fierce offensive started, Drenica was fully seized. I can say an iron siege in Chires, and on our way to Chires, we saw a situation where people were moving around, running in different directions, asking each other, where are you going? Where am I going? It was a situation when people were at a crossroad, not knowing who was going where, a situation that cannot be described as a consequence of this brutal Serb offensive, and they were really very worried. Until 14 hours yesterday, meaning after 48 hours, when they informed us that now you are free and that we kept you in detention for 48 hours. They were first interested to know why we had not announced the visit, which I consider we are not going to announce our visits any time, and we're going to other territories as well, because, like I said, it is our obligation to go to our people, to our lands. We were not threatened in the real sense of the word threat. In my view, it is just that our stopping was senseless. It has no sense whatsoever. There was no reason for us to be stopped. While we're all public persons, we were people whose public activity obliged us to work every day, and we have done that in a legal way. Therefore, we did not go there to do any sort of propaganda whatsoever, be it political or party-related, against or pro the KLA. So, as I said at the beginning, our mission was of a humanitarian character. The forces, the unit that we met, they behaved in a correct manner with us. While about us, other parties, being closer to President Rugova, I consider that all the political parties have all due respect for Mr. Rugova, for President Rugova, the President of the Republic of Kosovo, who won the vote of the people of Kosovo in the last elections. I'm not aware of what arguments they had, but I can tell you publicly that from all the participants there, it was nowhere said or written that we are against the Kosovo Liberation Army, against the institutional organization of Kosovo.
While the parliamentarians clearly do protest at the fact that they were detained, they also clearly indicate, quote, "We were not threatened, not in the real sense of the word threat," and quote, "The forces, the unit that we met, they behaved in a correct manner," close quote. And contrary to the prosecution's allegations in the indictment and what was told to you yesterday, these parliamentarians did not appear to have any, quote, "visible injuries," as alleged by the prosecution. For now, we leave it at that concerning the allegations about the events at Chires, but we will have much more to say during the cross-examination of the prosecution's witnesses. The following slides are not to be shown to the public. Finally, we turn to the allegations against Mr. Thaci concerning the disappearances of two individuals in Drenac. The prosecution alleges that in June 1998, two opponents who had been arrested, interrogated, and in one case severely beaten by JCE members and tools at the Drenac headquarters were taken in the direction of the KLA General Headquarters by Hashim Thaci and Kadri Vaseli personally, with Recep Salimi also present. The detainees were never seen or heard from again. Slide 123. The SPO has no credible evidence that Mr. Thaci was involved in the disappearances of these two individuals, and that is because he had no involvement whatsoever.
occurred during the indictment period. As this opening statement clearly revealed, this evidence is simplistic and oftentimes wrong. The violence was an outgrowth of multiple reasons. The chaotic war was localized at a grassroots support by people trying to protect their homes and their villages. And frankly, the Kosovo Albanians were fighting for their lives. Command and control, the SBO would have you believe that the vertical command and control within the KLA operated without any mistake or deviation, if I will, along the way. Such is not the case. There was no effective command and control, and we need not point to any other incident than the zone commanders changing the general commander of the KLA by their own decision without consultation with Mr. Thaci or anyone else. In addition, there's no indication from the SPO that they have incorporated what was happening on the ground. This was a war. This was a war against one of the greatest armies or most powerful armies in Europe, the Yugoslav army. Yet there is no indication or explanation or discussion by the SPO as to what the attacks by the Yugoslav army and the military police in 1998 and 1999 did to the command structure to the KLA, put aside what it did to the KLA battalions and brigades on the ground. What we will find during the course of this is that those brigades were decimated in virtually every zone in Kosovo. Hashim Thaci was part of the political directorate. He didn't have any control over troops and certainly didn't have any control over detention centers that were located in sparse locations in villages throughout Kosovo. On a pure motive issue, any violence directed against civilians certainly would have undermined Hashim Thaci's standing with the international community after they were specifically told there were not to be attacks against the civilian population, and any such attacks would have been adverse to his personal interests. In sum, Your Honors, contrary to the statements and position taken by the SPO, Hashim Thaci was not a man that wanted to take over Kosovo. What has been demonstrated on numerous occasions, by not the least of which is the videos that were being played during Mr. Misicic's presentation, that he was trying to bring about a peaceful ethnic society with reconciliation to all parties at the same time that he was demilitarizing the KLA and formulating a police force. Clearly, these are just some of the facts that we will bring into evidence, but even these facts militate against any position that the SPO has advanced, that they were part of, that my client, President Thaci, was part of some common criminal purpose to take over Kosovo. Such was not the case. Your Honors, thank you for your attention in this regard. We will not have this opportunity to address you directly in this fashion until the end of the case, and we look forward to that moment. At that moment, we're going to ask you to enter a plea of a verdict of not guilty for President Thaci, because we are confident that the evidence that we presented in this trial, both by the SPO and by the presentation that we will make, will adequately and fully support a position of not guilty. Mr. President, with your permission, if the court could just give the floor to our client for a brief comment, it would be greatly appreciated.
How much time do you expect?
5 minutes.
Right.
Although it may, I'm told it may bleed into 7, but I'm not sure it's going to be more than that.
Mr. Thachi, you may stand up if you're comfortable standing. You have the right to make an unsworn statement. You have the right to make an unsworn statement. We grant you that right at this time. Please confine your remarks to 5 minutes. Thank you.
Faleminderit shumë nderuar zoti kryetari i trupit gjykos.
Thank you very much, Mr. President, Judge Smith, Your Honors, Judge Medron, Barth Gaynor. Thank you very much for the opportunity to briefly address you today. Today we are embarking on a journey together, a journey towards truth and justice. Truth and justice are principles that I hold dear. They are the cornerstone of all democracies and the foundation of peace. Let me make myself avail of this occasion to say that I feel sorrow and pain for all the victims of this terrible war, regardless of their ethnicity, religion, or political views. Victims do not obtain justice when the innocent are pursued. One injustice cannot be cured and corrected by another injustice. I am innocent of all these allegations. However, I'm ready to face this new challenge and succeed for my family, my people, and my country. Our journey to freedom was long and hardsome. I was a student in Switzerland, a political exile, when the Ashari family was massacred in March 1998. Like many Albanians in the diaspora, I returned to help my country too, and I joined the resistance for the freedom of Kosovo. Everyone in our place would have done exactly the same thing when freedom was taken away from them. The KLA was made up of simple people, volunteers trying to defend their homes, their families, and their dwellings. They fought, and many died bravely. This was the price to freedom. Thousands of families lost their loved ones in hundreds of massacres committed by the Serb forces. Our opponents were the Serbian army, police, and paramilitaries who were battle-hardened in killing fields of Bosnia. Dear participants, dear panelists, both the peaceful and armed resistance shared the same goal of freedom, statehood, and democracy for Kosovo. And without popular resistance, there wouldn't be a Kosovo today. The people of Kosovo did not want war. They instead wanted peace. War was imposed to them. They did what any freedom-loving people would do to protect their families and their children, to protect their home country. So we, the Kosovo, were in the right side of history. Today, I'm happy that the people of Kosovo live in a free, independent Kosovo based on equal rights and on the rule of law. So Kosovo is a success story. During this trial, we will travel back in time to the events that took place 25 years ago. I ask all those who listen in to keep in mind that memories over 25 years have been blurred. Reality has been conflated with opinions and different agendas. Speculation has become fact. Also, emotions, as well as political reaction of every political stakeholders should not be understood as facts in this court of law. This is also true for some publications and opinions after the war that are exaggerated or adopted to serve interests of different actors of the war. Like in every democratic society, in our country as well, not every co-warrior of the law was as well a person accompanying us in the political processes after the war. In not a few cases, ambition, political interests, and personal ego go beyond truth and reality for the storytelling of the KLA and the history of Kosovo itself. So people believe what they want to believe is the truth. However, we have a historical and factual record captured at that time. We must go back to that record because it is there the truth can be revealed. I regret to say that we will not have the opportunity to hear in this court of law the testimony of the Secretary of State, Madeleine Albright, Foreign Secretary Robin Cook, Senator Robert Dole, Ambassador Richard Holbrooke, Mr. D'Amelio, that was the first head of unmaking Kosovo immediately after the war, of President Ibrahim Rugova, of Professor Femi Agame, of Adem Demace, and other leaders. They would have testified on my behalf about what I have said and what I did during that very important time in Kosovo's history. I'm happy that many others like them have come forward to testify about my innocence. We believed in ourselves. We believed in our determination to be free. But all of us in Kosovo knew all along that without the help of the international community, and in particular the help of the United States of America, we could never be free and independent. We in Kosovo have always supported justice and international justice in particular. When Dick Marty's report 13 years ago hit the international headlines with those lurid allegations of organ trafficking by the Kosovo Liberation Army and me in person, I immediately asked the international community to investigate independently. The international community told me that a special court was essential to lift the black clouds of organ trafficking allegations hanging over Kosovo. The world now knows, as a result of these proceedings, that there was no organ trafficking and that the Yellow House never existed. We now know that both myself and the KLA, as well as the people of Kosovo, as well as all Albanians, have been vindicated of those allegations. The truth has been told, and the black cloud over Kosovo has been lifted. Therefore, this sacrifice was worth it. I expect to be vindicated of any remaining allegations against myself at the conclusion of this trial. This is the fourth court by internationals after the ICTY, UNMIC, and ULEX for the same charges. I've been interviewed by all the international justice mechanisms at the quality of a witness or of a suspect as well. Every cooperation of myself with all these international justice stakeholders has been in the interest of justice and has been totally transparent, both in Pristina and in The Hague. Anything else said regarding this does not stand. Therefore, nobody can rewrite history. This is the price of freedom. I hope and I have full trust that this process is going to be transparent and expeditious. Thank you very much for your attention.
Mr. Thaci. I think rather than starting with Mr. Emerson now, we'll break for lunch and you can come back and have that. I will ask the Salimi defense, would you, I assume Mr. Emerson is going to be 45 minutes or so. Would you be able to start your do your opening statement yet today?
Your Honour, excuse me, sorry. Just to say I'm going to give my friend Mr. Roberts the chance to speak here.
Fine.
Thank you.
Thank you. Don't need permission. Your Honour, I would be perfectly willing to start this afternoon if necessary, but I would prefer to have a straight run, so it would depend on the duration of Mr. Vaseli's.
Are you going to use 1 hour, is that it?
I'm going to use 1 hour in conjunction, including 10 minutes for Mr. Salimi. So my speech will be approximately 45 to 50 minutes, and Mr. Salimi's will be 10 to 12.
And Mr. Emerson, are you still with 45 minutes?
Slightly less, I think.
Oh, okay. All right. So we will adjourn now until 2 o'clock. Everybody be back at 2, and we will begin with Mr. Emerson and then proceed onward. Thank you.
Thank you, Your Honor.
All right. All right.
Be seated. We will hear the opening statement from the Vaseli defense. Mr. Emerson, the floor is yours.
I'm grateful. Your Honours, I'm going to confine my brief opening remarks to the identification of certain key themes and issues that on behalf of Mr. Vaseli, we're going to invite you to focus on and keep firmly in mind as the evidence unfolds. Firstly, 25 years after the trauma, the massacres, the upheaval brought on by the conflict in Kosovo and the Serbian campaign of ethnic cleansing, Kosovo remains a country rife with speculation portrayed as fact, with rumour and counter-rumour, with claims and counterclaims, with grudges and even blood feuds. Elements of this culture have existed for centuries, but it continues even to this day. Not surprisingly, the 1998 war has led to a great deal of myth-making over the past 20 years, and shortly before the adjournment, in his final comments, President Thaci referred to the organ trafficking myth. It's just one of many stories that perhaps through some malevolence, perhaps through amplification, through the retelling, has gained a footing that was not founded in fact. The history of the war has also been written and rewritten in memoirs, newspaper articles, interviews, books, often slanted to serve the legacy interests of various protagonists. But it has also, and separately, been the subject of more considered and more careful judicial examination in trials, inside Kosovo, in courts established by UNMIK and then ULEX, and of course here in The Hague at the ICTY. And it goes without saying that not everybody involved in those events is an equally reliable historian. Some people have tended to exaggerate their own role and importance within the KLA, often for present day or contemporary political purposes. But others have tried to distance themselves from events they were in fact involved in because they know that some of their actions were, to say the very least, highly questionable and might land them in front of a criminal court. All of this is further complicated by the war propaganda put out on behalf of all sides during the period of the conflict itself. And of course, the events with which you will be concerned occurred nearly 25 years ago, and with or without bad faith, memories can become distorted and confused over that length of time. Taken together, these factors obviously create a challenging environment for reliable judicial fact-finding. To adopt the familiar aphorism, truth is the first casualty of war, but in this context, that is a description that is particularly apposite for reasons that will unfold with the evidence. So you are going to be confronted with a factually confusing picture of a chaotic period in the history of this small nation amid events which upended the lives of every family in Kosovo. The central challenge, of course, for any judicial tribunal in these circumstances will be to sift the facts from the rumours and to separate hard evidence from recirculating allegations which have acquired the status in some people's minds of assumed facts. I'm going to abide in these remarks by your injunction to avoid repeating the contents of the defence pre-trial brief for Mr. Vaseli. You already know that the defence fundamentally disputes the prosecution's characterisation of the KLA as having been from the outset a top-down organisation or one that was either led, managed or micromanaged by individuals who came to be known as members of the General Staff. Witness after witness in the previous ICTY proceedings have characterized the power structures within the KLA as essentially horizontal rather than vertical, with both zone commanders and indeed even local commanders, local area commanders, exercising very high levels of autonomy and considering themselves to be, and being, operationally entirely independent of each other and of the General Staff. That is why, to describe, as the ICTY has held, to describe the body that called itself the General Staff as a General Staff in any conventional sense is entirely misleading. Of course, in a guerrilla army, rapidly thrown together in the spring of 1998 and made up almost entirely of poorly armed and untrained Albanian civilians, attempts were made by those presenting the KLA to the outside world to make it appear more organised, more unified, and more effective than it really was. Propaganda was used by all sides, including the KLA. But the materials available to you include not only the judgments and findings to this effect of the various ICTY cases relating to the conflict in Kosovo, but also the transcripts of the evidence given by prosecution or defense witnesses, but primarily prosecution witnesses, in those proceedings. Just to give you a flavor of the reality or otherwise of the prosecution's submission that this was, from the very beginning, a top-down organization. Colonel John Crosland was the British military attaché to the UK embassy in Belgrade. He was called to give expert evidence by the prosecution in the Haradinaj trial. Colonel Crosland testified that in the spring of 1998, when the Serbian serious offensive began, the KLA numbered only about 30 or 40 active members inside Kosovo, using what he memorably called shoot and scoot tactics. Having been in Kosovo himself at the time, and with access to high-grade intelligence, he testified about the aftermath of the Serbian attacks on the KLA strongholds in Prekaj and Glojan during March 1998. He described the build-up of Serbian forces as both regular Serbian military and irregular paramilitary formations flooded into western Kosovo, and described a tidal wave of fear spreading very quickly across the countryside as local village defences, which had existed long before the conflict and were an essential part of Albanian rural community life, try to organise themselves into something resembling a coherent line of defence against the advancing Serbian forces and what they expected to be a repeat of the Bosnian ethnic cleansing campaign, escalating indeed to a risk of genocide. Another witness who gave evidence to the ICTY and who is due to give evidence before you is Bislim Zairapi. He became chief of the KLA General Staff, and he is the witness relied upon by the prosecution to produce and comment on many of what was described yesterday as the KLA regulatory documents, the codes, the descriptions of conduct and so forth that were shown by the prosecution to you yesterday. But as the SBO must know, Mr. Zairapi has testified on multiple occasions about those documents here in The Hague, giving evidence to the effect that those regulations were purely aspirational and never in fact put into effect. They were drafts that bore no relation to the realities on the ground, according to the SBO's own witness to those documents. They were created, said Mr. Zairapi, as part of a plan to professionalise the KLA at the end, or towards the very end, of 1998, in order to convert it from the chaotic guerrilla force that had just been utterly routed by the Serbian spring and summer offensives into something resembling an army capable of defending a civilian population against what was expected to be a long military campaign, liable to involve substantial levels of ethnic cleansing. Of course, no one at that time, November, the end of the year, 1998, could predict if and when NATO forces would in fact reach the point at which they would be prepared and reach the decision to intervene against Serbia to prevent another Bosnian genocide from materializing. No one, that is, except perhaps Kadri Vaseli, because it was his role to liaise directly with the intelligence personnel, not only of Albania, but also of certain NATO member states, who were, of course, watching the position inside Kosovo very closely indeed. And for that purpose, he spent one of the key periods of the conflict outside Kosovo altogether, liaising at an intelligence level with the intelligence services of those state entities. You know from the Vaseli pre-trial brief that when you're looking at the case of Mr. Vaseli, the indictment period, or period of armed conflict, I should say, has to be divided into three distinct phases. The first phase then, from the spring of 1998 until the late autumn, is the chaotic period during which attempts were being made to establish some sort of network of structures on the ground between zones and village defences, which were then almost immediately overrun by a highly professionalised Serbian military campaign, which targeted not just the KLA, but the entire civilian population in its way. Villages were surrounded, bombarded, and then when villagers were given a safe corridor to leave, mopping up operations, as they're called, were carried out by MUP forces on the ground, entering the villages, shooting anything that remained in the village alive, burning the crops, looting the houses, often burning the houses as well. That was the first period. At that time, you will hear, there was no internal intelligence function operating at the level of the General Staff at all. This was the time of those offensives, which largely destroyed even the local organisation, or the pockets of local organisation on the ground. The second period was between the end of autumn and the spring of 1999. In the second half of November 1999, you've heard there was a degree of reorganisation with roles, particular individual roles, being ascribed to different people as members of the General Staff, and Mr. Vaseli was appointed as the head of intelligence. And one of the key questions that this court is going to have to decide is what that appointment meant in practical terms. The best assistance as to what the intention of that appointment was is derived from what actually happened. As soon, or virtually as soon, as Mr. Vaseli was appointed head of intelligence, he left Kosovo to perform his role as head of intelligence and was based outside the country, liaising with international intelligence and other agencies until just before NATO made the decision to commence its bombing campaign. So his function is evident from the timescale and from his movements. As he has explained clearly in the pre-trial brief, his intelligence function was focused on liaison outside the country with the intelligence apparatus of Albania and certain NATO member states in anticipation of what was to come. His function had nothing to do with internal intelligence and nothing to do with tracking down collaborators. He was focused, as I've said, exclusively on international intelligence liaison, and that is why he was based outside Kosovo for the approximately 6-month period between his appointment as head of intelligence and the commencement of the NATO bombing campaign itself in March of 1999. So he wasn't, as the prosecution implied, based in the Berisha Mountains during this critical period. He was focused and operating outside Kosovo for that contribution, important, vital contribution to the war effort. The prosecution told you yesterday of the thousands of people they have interviewed at all levels of the KLA, from simple fighters to zone commanders and even former members of the General Staff. They told you of the length and depth and breadth of their investigations within the KLA itself, as well as amongst others outside the KLA. And yet not a single person they are proposing to call ever saw Kadri Vaseli doing anything remotely untoward. Until last week, there was one witness on the prosecution's witness list. Although he was deceased and although his evidence was on paper, there was one prosecution witness who made a claim to have seen Mr. Vaseli on one occasion in Kukes interviewing a detainee, which might put him somewhere towards the allegations that the prosecution is mounting here. But it was obvious from the outset, and having seen the witness's later statements and evidence, that this witness was entirely mistaken in his identification of Kadri Vaseli, and indeed he said so himself. The reasons for that are set out in our pre-trial brief at paragraphs 53, letter E. Last week, on the eve of the trial, the prosecution notified the defence that it now accepts that this witness was indeed mistaken in his identification of Mr. Vaseli, and that the prosecution is therefore no longer proposing to call any evidence in support of the allegation relating to that instance, which you will find referred to at paragraphs 49 and 120 of the indictment. That is no longer maintained. The position of the prosecution is that it is unnecessary formally to amend the indictment to reflect this. That obviously is a matter for them to consider, but they do not seek to maintain it or do not propose to call any evidence in support of it. I think it's a drafting reason because it's not a separate count, it's an incident in a count. Therefore, say the prosecution, they don't need to amend the indictment, although it might be helpful to the trial panel to know that allegation was not being pursued. But Your Honours can, however, at least mentally cross out that aspect of those paragraphs 49 and 120 of the indictment because the prosecution has unambiguously confirmed that it will not be leading any evidence in support of that accusation. It was a mistake. But once that evidence is gone, once that allegation is removed, there is literally no one out of the thousands of witnesses interviewed by the prosecution who claims to have seen Kadri Vaseli do anything even remotely untoward in this case. There is no witness claiming to have seen him present at any time when any crime is alleged to have been committed. There is no evidence that he ever authorized or instigated any crime or any criminal policy, that he ever received in his capacity as head of intelligence any report of any crime being committed, or that he ever played any part at all in the events leading to the commission of a crime. There is no witness evidence on those subjects at all. Nor is there any evidence whatsoever that he failed to take steps within the scope of a superior-subordinate relationship to prevent any crime or to punish those responsible. This is all absent. The same is true for the documentary evidence relied upon by the prosecution. There is simply no probative documentary evidence even relevant to Mr. Vaseli. With one exception, which I'm going to turn to in a moment, there is not a single document in the entire case, despite the thousands of witnesses the prosecution have investigated, all of the great plethora of material seized and available to the prosecution from the ICTY and all the ULEX trials and all of the other proceedings. There is not a single document in the entire case that bears his signature. There is no evidence of him ever having given any written, or for that matter, oral, orders to anyone. And there is no evidence of him ever having received a written or oral report from anyone, whether in relation to collaborators, internal intelligence, or anything else. There were no documents seized from his home, and there is quite literally no documentary evidence of any kind concerning his role. The one exception I mentioned refers to a meeting on the 31st of October 1998 in Tirana. For the record, it's ERN 061168. You've been shown it twice, once during the prosecution's opening and once during Mr. Kehoe's opening remarks. This was signed at a meeting in Tirana concerning the integration of FARC forces, that is, the military group associated with the Bukoshi government and the LDK. It's an agreement for them to join with the KLA in a single fighting force in Kosovo. So this was not evidence of any kind of persecutory policy. This was evidence of an agreement reached with the Bukoshi government in exile that the two forces should combine their strengths together. And Mr. Vaseli was one of the counter-signatories to that. Once again, it's obviously significant that this was a document signed outside Kosovo in Albania's capital, Tirana. Far from supporting the idea that Mr. Vaseli was part of a conspiracy to persecute supporters of the LDK, the one document that bears his signature attests to the voluntary incorporation of FARC into the KLA as a single fighting force. One of the fallacies at the heart of the prosecution's case, which seems to be based on the views of a relatively small number of individuals, is that the notion that the KLA leadership conspired together to target supporters of the LDK for persecution. But as you will hear, that is an entire misconception of the situation on the ground, because the majority of KLA fighters were in fact members or supporters of the LDK. These were not two separate groups. They were utterly intertwined. Of course, there were conflicts, there were differences, like there would be in any series of political movements joining forces. But the notion that there was a persecution policy against the LDK is utterly belied by the fact that most KLA members were LDK supporters. So in the many thousands of hours that the prosecution has spent interviewing witness evidence, they haven't turned up a single eyewitness or a single document that can be relied upon to show that Mr. Vaseli played any role in furtherance of the joint criminal enterprise they allege to have existed. Yet the prosecution is seeking to hold Mr. Vaseli vicariously liable for the criminal conduct of individuals on the ground who committed crimes he knew nothing about and had nothing to do with. You will wait in vain for evidence implicating Mr. Vaseli during this trial, or showing that he was a party to a joint criminal policy, or that he ever did anything at all to further the purposes of the alleged joint criminal enterprise, or that he ever had any effective control of zone commanders, local commanders, or fighters on the ground. In framing its case against Mr. Vaseli, the prosecution has fallen into the elementary category error of assuming that the mere fact of his appointment as head of intelligence towards the end of November 1998, without more, can be equated with a leading role in a unified internal intelligence network aimed at identifying collaborators. They haven't even asked themselves at the outset, or in any way set out to prove, what type of intelligence function he could have been performing when he was outside Kosovo, clearly liaising with the intelligence services of other states. In his pre-trial brief, Mr. Vaseli has spelt out clearly why that, we would say, lazy equation, based on a name alone, is not a valid basis to draw any inferences about Mr. Vaseli's actual role. When he left Kosovo, it wasn't to depart the conflict, it was to further the interests of the conflict, but with international partners. Identifying, detaining, and mistreating alleged collaborators inside Kosovo was no part of his function at any time. As Mr. Whiting, and Ms. Lawson emphasised in their opening statements yesterday, the prosecution brings this case, and as against each and every defendant, the prosecution must prove the allegations beyond a reasonable doubt. In the case of Mr. Vaseli, that necessarily involves disproving, beyond reasonable doubt, the defence that is clearly set out in his pre-trial brief. That is the case they have to meet. He says he was concerned exclusively with external, that is international, intelligence functions, and that is why he left Kosovo as soon as that role was given to him. Why else would he have done so? If the prosecution cannot disprove that, and there's nothing in the evidence served so far which comes close, then Mr. Vaseli, of course, is entitled to be acquitted, as he should be. Merely pointing to the fact that he was given a role named head of intelligence is obviously nowhere near sufficient to get the prosecution even off the ground. They must prove, to the requisite standard of proof, exactly what that role involved and exactly why they've considered themselves able to say to you that the adoption of that title, or the conferring of that title, proves that he was in fact involved in a domestic program, indeed running, according to the prosecution, a domestic program designed to penetrate through the zone commanders right down to the level of an individual being picked up in a local area of Kosovo because, for whatever reason, the person who's picked them up believes them to be a collaborator. With the greatest of respect, once a full understanding, and it will emerge, of what was going on in Kosovo at the time and what was not, would make that idea as ridiculous as the organ trafficking allegations. The role of the General Staff was nothing like a General Staff in a conventional army, and it's fanciful to pretend that it was. It's also fanciful to pull out documents that were in draft form, never put into effect, and purely aspirational. This is what we would do if we got our act together, as Mr. Zarafi will explain, as the prosecution must know he's going to say, because he said it so many times before. To jump from that to an allegation of this nature is, in our submission, entirely illogical and impermissible. But outside that easy assumption, there is nothing for the prosecution to rely on. It rests on that assumption based on the name of his role. And it's that kind of easy assumption, or as we would perhaps, I hope not pejoratively put it, lazy equation, that generates the all-pervasive habit of myth-making that has so often characterized analysis of the conflict in Kosovo. So where, one might ask, is the actual evidence of Mr. Vaseli's involvement in a joint criminal enterprise to ill-treat collaborators? Where is the evidence of his actual role? Well, someone must have been liaising with the intelligence services of Albania and of NATO member states, and they must have been doing that outside Kosovo. If the prosecution is setting out to prove it wasn't Mr. Vaseli doing that liaison, then who does the prosecution say it was doing that intelligence liaison with the intelligence services of those states? And if it was Mr. Vaseli, then how can that role be connected to an alleged conspiracy to detain and mistreat collaborators inside Kosovo? Perhaps one might think Mr. Vaseli, because he was in Albania a lot of the time, was a frequent visitor to the two detention sites identified by the prosecution on the Albanian side of the border. But there is nothing at all to that effect. Nothing anywhere in the evidence to suggest he had any involvement whatsoever in the identification or detention of alleged collaborators. What about the communiques? Well, these two certainly had nothing whatever to do with Mr. Vaseli. He never wrote any of them. There is nothing to suggest he approved them in advance in any way. None were found in his possession. But most importantly, they have all of them, all of the ones that the prosecution rely on. This is not an area of new evidence. They've all been considered in full by the ICTY on multiple occasions. And as Mr. Msetic pointed out, the ICTY has consistently characterized them as war propaganda on which no reliance could safely be placed as the basis for a finding of fact. And above all, in the sense that they refer to reprisals against collaborators, they were referring to a military strategy against those perceived to be posing a military threat. You will obviously want to examine carefully those that were issued during the indictment period, not those that were issued in 2004 and 5, those that were issued during the indictment period. But as you do, I would ask you to bear in mind throughout that there is nothing whatsoever to connect Mr. Vaseli or the role that he played carrying out intelligence functions outside Kosovo with those documents. More generally, during the prosecution's opening, you may have noted the relatively limited references that were made to the evidence concerning what the prosecution say was the actual role of Mr. Vaseli. I'd invite you, I'm sure you will, reread the transcript of the SPO's day of opening. But the references to Mr. Vaseli's role consisted, for the most part, of hypothesis unsupported by any citations to the evidence in support. The prosecution did single out one handwritten document alleged to have been found in the possession of Mr. Krasniqi, I believe. It was presented to you as slide B31, and I think its full reference is SPOE 00227535. It was displayed on the screen by Mr. Halling, written in a manuscript. And there was a section of it which Mr. Halling took you to, which purported to describe the function of KLA intelligence. No mention of Mr. Vaseli, but of what a KLA intelligence function should involve. It was, in fact, it's a single page taken out for the purposes of exhibits from a manuscript handwritten notebook. But the provenance of it is entirely unknown. There's no evidence to suggest it was written by Mr. Krasniqi, or indeed who it was written by. No one knows who wrote it, when it was written, where it was written, or for what purpose it was written. It is entirely devoid of evidential worth in the absence of that material. It is a worthless, in the true sense, a worthless piece of evidence. And yes, it occupied such a prominent position in the prosecution's analysis of its own case that it was pulled up on the screen by Mr. Halling and identified and quoted from in that passage. The very fact that that document, that unprovenance document, that piece of paper that might have well have been picked up from a rubbish bin off the streets of The Hague, evidentially, that document, the very fact it was singled out by the prosecution to describe its case against Mr. Vaseli as regards the intelligence function, is the loudest and clearest possible testimony to the fact that there is no actual evidence implicating Mr. Vaseli in any of the conduct alleged by the prosecution relating to this claimed joint enterprise. This note, scribbled by an unknown writer, who knows when or where or why, doesn't even mention Mr. Vaseli's name. The other piece of evidence highlighted by the prosecution in its opening, if it can properly be called evidence, was that Mr. Vaseli, it is said, was given his nom de guerre, Luli, at the KLA enclave in Jablanica. You'll remember a deal was made about that because we heard a bit about the Jablanica cowshed in which people were being detained at various points in time. And the point was made that at some point in time, it is said, Mr. Vaseli's nom de guerre was invented at Jablanica. Jablanica is a small village deep inside the Dukajin zone in western Kosovo. It's been the subject of detailed examination in the Haradinaj case. It is a place where it is known that a number of individuals were detained and severely abused, and at least one, possibly more, lost their lives. What the prosecution does not and cannot allege is that Mr. Vaseli was ever involved in any of those events, that he was even aware of the detention of any person at Jablanica at any time, or that he was ever physically present in the village at a time when any person was detained there. But as Mr. Mesesic said, that particular instance is worthy of a rather deeper dive at this early stage, because it tells us quite a lot about the prosecution's case theory, particularly its case theory on joint criminal enterprise and command and control. And we would suggest Jablanica is a very important case for your honours to consider. The commander at Jablanica was a man called Lahi Brahimi. Mr. Brahimi was convicted by the ICTY in the Haradinaj trial and sentenced to a term of imprisonment for the crimes of abuse, violence, torture, and so forth, that he and his immediate subordinates at Jablanica committed against certain people held prisoner there. Mr. Brahimi's cousin was Ramesh Haradinaj. And Ramesh Haradinaj was the overall zone commander of the Dukajin zone at that time. He was therefore the commanding officer over Lahi Brahimi and the Jablanica enclave. He, on the evidence, visited Jablanica on a number of occasions. And Lahi Brahimi was certainly, at least nominally, under his command. Yet two successive trial chambers of the ICTY held in terms that despite being the zone commander, if you like, the line manager, Mr. Haradinaj was not party to a joint criminal enterprise with Lahi Brahimi to detain and mistreat the prisoners abused at Jablanica by Mr. Brahimi and his men. And yet here, as Mr. Mesesic pointed out, the prosecution is relying on those same acts of abuse by Mr. Brahimi and his men, undeterred by the findings and analysis of the ICTY. The prosecution is now claiming that because Mr. Vaseli was a member of the General Staff, he should be held vicariously liable for what Mr. Brahimi did. But the effect of the ICT judgment in Haradinaj, and it hasn't been appealed, this is the retrial in Haradinaj, is that any joint criminal enterprise to mistreat prisoners at Jablanica was confined to those KLA members who were under Mr. Brahimi's immediate command there. That was the joint criminal enterprise. It was a Jablanica JCE. It was not a joint criminal enterprise that extended as far as the zone commander. So how, one might reasonably ask, could it have extended to Mr. Vaseli simply because he was a member of the General Staff, with no additional evidence whatsoever? Those are precisely the sorts of questions your honours will need to ask, regrettably, when evaluating each of the crime sites on the indictment. How does the prosecution connect this to the individuals in the dock? You can't bypass the zone commander and then say it's a top-down organisation where everyone's doing what they're told by the person above them. And yet here we have a situation where there's a JCE found, which we're going to rely on, but we're going to leapfrog the command levels in between and stick to our story. I mean, you'll see these types of, if I may respectfully say, Janus-faced means of analysis marbled through various aspects of the prosecution case. I'm very close to finishing. I'm just conscious I'm a minute over time, but I'll be finished in 1 or 2 minutes. In her closing remarks yesterday, Ms. Lawson stressed that the prosecution was not simply relying on the pattern of detentions, the instances of mistreatment, to prove its case. But at least so far as Mr. Vaseli is concerned, it is difficult for them to sustain that position because they have no other independent evidence pointing to his guilt on which they could rely. It follows that it will be of vital importance for your honours to examine that alleged pattern in its numerical context, its comparative context, its temporal context, and its geographical context. The numbers who were actually detained, the numbers who were actually mistreated, particularly during the periods of intense fighting, the distribution of these incidents over the 15 months or so of the active conflict, and thereafter, once the conflict had ended, and across various parts of Kosovo, as well as, noted by the Limai trial chamber, the myriad possible motives that may exist for those on the ground who committed the crimes, none of whom are going to be in the dock or giving evidence to you. All of those variables, and they are massive, will need to be very carefully assessed and critically examined. There is a, I think Mr. Keogh put it, simple and simplistic approach that the prosecution takes. You, I'm sure, won't be seduced by so superficial an analysis. If they want to make this case, then they need to prove it. The prosecution's case rests on the proposition, carefully managed so that you saw all the dots appear at once, not over time in their appropriate order, but pile them all on at the same time, concertina them into one slide, and then put a dot in the middle where the General Staff sometimes used, or some of them sometimes used, their headquarters, and it's all graphically presented as though it was a real case. But in reality, the prosecution, to make their case good, they have to rest on the proposition that the crimes were either so frequent or so numerous or so closely characterized by similarities of motive, of identification, and so forth, that they can only have been the result of a policy adopted by the General Staff. You're not going to find the policy anywhere. We would say you're not going to find it anywhere because it didn't exist. You're not going to hear any evidence from anybody saying there was a policy, because otherwise we'd know about it from the prosecution. You're not going to find a document implying the policy. So unless they've got evidence against each one individual in the dock that says, well, we can infer you must have been involved because there's this additional evidence in relation to you, this case doesn't get off the ground. We've had men in 2 years in custody with another at least 2 years in trial on the basis of a case which lacks substance altogether. But it will, I concede, require you to look very carefully at whether the rather vaguely presented idea of patterns and inferences really stands the proper critical scrutiny that a criminal court will give it to the appropriate standard of proof. We say your honours will, of course, have to examine it critically and with care, but where the facts of particular cases have been proved in judicial proceedings here or in Kosovo, you will at least have a solid basis of fact on which to base your findings about that particular instance. But the true extent of the crimes, which we say are very significantly inflated by the prosecution, and in some respects the numbers, it's difficult to see how they reach the conclusion because they include people in respect of whom findings to the contrary have been made. But that's all a matter for the manner in which the case unfolds. But the true extent of the crimes and the inferences that can safely be drawn to the criminal standard of proof from their commission is obviously a matter very much for the court to determine, having heard all the evidence. But what can be said from the outset is the prosecution has disclosed and served no evidence whatsoever linking Mr. Vaseli to that pattern of crimes or to the alleged JCE, beyond the fact that in late November, just before he left Kosovo to do his job as an international intelligence liaison, he was appointed head of intelligence, only returning just before NATO pressed the button. The fact that his role was called head of intelligence is no substitute for evidence, Your Honours.
Thank you, Mr. Emerson. We will now hear the opening statement from the Salimi defense. Mr. Roberts, the floor is yours. You have 1 hour.
Thank you, Your Honour. As I mentioned just before the break, it would be Mr. Salimi, with your leave, who will speak first for about 15 minutes, and then I will take up the rest of the hour.
So you want Mr. Salimi first?
Yes, please, Your Honour. Thank you.
Mr. Salimi, you have the right to make an unsworn statement, and you may do so now. And please confine yourself to I'm sorry, you said 15 minutes? Pardon?
Maybe less. Maybe.
In the rural.
Honorable trial panel, honorable people present in and out of the courtroom. Almost 2.5 years have elapsed since I was notified that an indictment against me was filed by Kosovo Specialist Chambers. Obviously, I didn't expect this. Notwithstanding how the events unfolded, we are now here faced with an indictment that we rightly continue to consider unfounded on true facts and arguments. Therefore, I plead once again not guilty to the charges brought forward in this indictment. In the early 90s, I was a student in the University of Pristina in the faculty of Philology, Albanian Language and Literature. Like everywhere else in Kosovo, violence escalated in the University of Pristina as well. I remember when they expelled us from the dormitories. I was at dormitory number 2, when on the 16th of March 1990, armored vehicles and armed policemen near the student center could be seen taking Albanian students out. We could no longer enter university facilities, faculties, the canteen, or the library. Albanians were fired from their jobs. There were no Albanian policemen, no Albanian doctors, no postmen, or civil servants. Albanian youth were not allowed to play football in stadiums or gyms. The only Albanian language television was shut down, along with newspapers that had been published until then. Violence against Albanians was escalating. Albanian youth were being drafted into the Yugoslav army. They were not being sent to serve in the army, but to be killed. This is exactly what happened to many young men who were returned in metal caskets. I remember it as if it were yesterday when my peer Yetullah Desku was drafted to the armed services and after a while was returned in a coffin. His family was told he had committed suicide.
Mr. Salimi. Here. Please slow down a little bit for the translators.
Certainly. As I said earlier, I was in my teenage years and I was studying in the high school, Luigi Gurakuchi in Klin. Luigi Gurakuchi was a patriot, Albanian patriot and writer by the end of 19th century and beginning of 23rd century. And Serbia changed the name of the school, and that same year, they started to poison the students in my school. You can find the images of young people suffering close to death because of that organized poisoning against Albanian students in our schools. I could see my peers suffering in agony because of this mysterious poisoning against Albanians. This hunting against Albanian youth did not stop systematically to make them leave Kosovo. So in the early 90s, many of my peers had to abandon and were forced to leave Kosovo that they loved so much. At the time, I had two options: either stay in Kosovo and wait to be poisoned, arrested, or murdered, or be forcibly conscripted in the murderous Serbian army, or to avoid the situation, to leave Kosovo and join my family members somewhere in Germany or in the Netherlands. I could seek asylum as many other Albanians from Kosovo did. Between these options, I chose a third path. Instead of joining my family members who were in exile, I joined an even larger family. I joined the Ashari family in Prekaz. I left behind my dreams, my studies, and I became part of the Kosovo Liberation Army. At the time, the KLA was an army only nominally, but it didn't have many members. We had our will, but we had only few people and weapons. Being part of the KLA meant being an enemy of Serbia, and you could get yourself killed or at least arrested, like my brother Naslan, who was arrested and sent to Serbia's horrible prisons, or like my friend Besnik Restelica, who was strangled during tortures at the premises of Pristina's investigation office.
I was already being sought after by Serbia. I was being followed by them to get me arrested or killed. An indictment was filed against myself in the Serbian courts. Part of that indictment was as well Adem Yashari, as well as some other fighters were part of it. I could no longer stay in my family and at my home, and this is the reason why, together with my uncle, Mój Krasniczy, on the 10th of October 1996, I fled my home. It is from that day onwards that I spent most of the time with the Ashari family. There, I was staying with Adem, Shaban, Hamos. I was staying there with the children of that family. I was staying with Fatim, Besim, Kushtrim, Iqbal, and all the other children of that family. All these children names that I just mentioned to you were later killed by a Serbian attack against the Ashari family. And that happened on the 1st of March 1998, when a Serbian attack was launched on the Ashari family in Prekaz. On the attack day, I was not there with them. This is why I'm still alive today. Otherwise, I would have suffered the same fate as those that were killed that day during those 3 days of epic resistance of the KLA in Prekaz. In that battle, Adem Yashari and his family fell heroically during their resistance. We, the friends of Adem Yashari, that survives, stood against the entire Serbian army. We were very few boys and girls, men and women, poorly armed, without uniforms and disorganized. We were left fighters without a commander. Everything we could do was to follow Adem Yashari's path, die fighting or fight to win. Some did the former, that is dying while fighting, whereas others did the second, namely, they survived and fought up until the victory of the country. It was in those painful days for Kosovo that we kept up with our resistance, doing what we knew and doing what we could. We wanted to have a well-equipped army, but we didn't achieve it. We didn't manage to equip it as we wanted to. We wanted to have a well-organized army, but we couldn't organize it as desired. We strived to defeat Serbia, but we couldn't do it without external assistance. We tried to organize ourselves, to arm ourselves, but we didn't manage. We tried to do this in order to survive as the people of the country where we were born. We didn't have barracks, but we had instead the houses of our families and those of other families that provided us with shelter and food. We did not have a military academy, but our parents had taught us how to fight for our country and to protect ourselves. We did not have uniforms, but we invented them. Some of us bought them, and others painted some clothing in order for us to look like soldiers. I remember, as academic and painter Idris Berisha painting worker clothes with their brushes so that their clothing resembled the KLA fighter uniforms. Your Honors, war is never good for anyone. We have never chosen war as a profession or passion, but it was a necessity. It was necessary for us to survive as a nation and as a society. In the meantime, Kosovo's Albanian population was being subjected to brutal violence and oppression. Serbia committed hundreds of massacres where more than 12,000 Albanians were killed without sparing children, women, the elderly, and disabled. In addition to the murders, the Serb forces raped thousands of innocent Albanian women and girls. They burned down hundreds of thousands of homes belonging to Albanians and violently forced more than 1 million Albanians to flee Kosovo, which represents more than half of the population. However, we never responded in the same manner. As we were talking about war crimes, let us talk about the ones that really have happened. Let's talk about the massacres, be them the massacres of May, Rečak, Izbic, Radonic, Cluj, Rezal, Koblek, Gjysh, Makos, and hundreds of other massacres in which children were killed, even in their mother's arms. Let us talk about Dubrova, where Serbia executed more than 100 Albanian prisoners. Let's talk about the disappeared, of whom thousands still remain unaccounted for. Let's talk about all those criminals that have committed crimes but are still free out there. In June 1999, NATO and the allied countries intervened to help the people of Kosovo, and after 78 days of bombing, the war was over. Kosovo was finally free. After the war ended, those that took responsibility for order and security were NATO and the United Nations, respectively KFOR and UNMIK. Together, we tried to work for Kosovo to become a state, for it to hold free elections and build democratic institutions. After the establishment, as a result of this day, Kosovo is a sovereign and democratic state. However, after the establishment of this court, I've been frequently asked if I was afraid of justice. I have always stated, and I still repeat it to the day, I'm not afraid of justice, but we should all be afraid of injustice. In spite of this, I stand today in front of you with full confidence that at the end of these proceedings, you'll decide in favor of my innocence. I have to add, and as already highlighted here, my submission is that the differences between us with regard to our political opinions, especially during specific times of heavy political impact, however, they should not and cannot be used as judicial facts against us, the co-accused. In these moments, while I'm speaking, and I'm sure my compatriots, the citizens of my country, are watching us, I'm confident that together we will reveal the truth. And I, together with my fellow fighters, will get back to our country free, because at the end of the day, we have fought for our country and we have worked through our lives for it to be as it is today. Thank you very much for giving me the opportunity to address the court. Thank you.
Thank you. Thank you, Mr. President. Good afternoon, Your Honours. Good afternoon to everyone in and around the courtroom. It's my honour and privilege today to make this opening statement on behalf of Mr. Recep Salimi, sitting behind me in court. As I mentioned earlier, I expect to speak for no more than 45 minutes and don't intend to summarise the defence case set out in the defence pretrial brief as directed by Your Honours, and also will seek not to repeat what has already been stated by some of my colleagues. Indeed, there's not really a case for the defence to summarise at this stage before the SBO has even called its first witness. As you well know, Your Honour's role in making any final determination of criminal responsibility is to make your conclusions based solely upon evidence which relates directly to the material facts as set out in the indictment. No obligation weighs on the defence to disprove any allegation in the indictment, but remains fully on the SBO to remove every allegation beyond reasonable doubt. Yesterday, the SBO publicly accepted that this fundamental principle is interwoven throughout every material aspect of its case. We've also heard the SBO repeatedly assure Your Honours in both opening and closing its speech yesterday, through Mr. Whiting and through Ms. Lawson, respectively, that this case is not a prosecution of the KLA. It does not accuse everyone in the KLA, and the KLA is not on trial. However, despite these fine words, it is the actions of the SBO which matter, and specifically the choice of the SBO to file an indictment against Mr. Salimi and his co-accused on the basis of a JCE, which, in our submission, allows for the potential inclusion of any KLA fighter as a possible JCE member or tool. It is the SBO which is seeking to hold Mr. Salimi and his co-accused criminally responsible for everything that happened in Kosovo, and even in parts of Albania, throughout the indictment period, as if the decision to gain and exercise control over all of Kosovo in and of itself renders anyone who believed in that goal responsible for every action committed by others in furtherance of it. This choice by the SBO impermissibly conflates the justness of the decision by the Kosovo Albanian population as a whole to take arms against the Serb forces with what happened during the conflict that ensued. And in these circumstances, it is perhaps no wonder that Mr. Salimi and his co-accused feel a certain obligation to protect the legacy of the KLA when it is so clearly under attack by this prosecutor. However, the defence for Mr. Salimi will not fall into that trap. But our sincere assurance that this path will not be pursued vastly differs from ignoring the entire context of the case against Mr. Salimi, when that context is vital to understanding and assessing the charges in the indictment. Now, you heard in detail from counsel for Mr. Thaci this morning about the context of the conflict, and I do not intend to repeat what has already been said. However, on a more direct and personal level, you also heard from Mr. Salimi about the impact of the campaign of discrimination and persecution at the behest of President Milosevic on him and his peers, on his choices as a young man, and on the choices of large numbers of Kosovo Albanians throughout the years before the indictment period. No one who heard the nationalistic rhetoric spewed forth at that time against purported Albanian terrorists and witnessed the litany of crimes committed by Serb forces throughout the former Yugoslavia from 1991 onwards, from Vukovar to Sarajevo, from Prijedor to Srebrenica, could be left in any doubt as to what would be the inevitable consequence for Kosovo Albanians caught in the murderous path of the Serbian military machine. No one would be in any doubt that a desperate and embattled Serbian president would be more than happy to use whatever means were necessary to demonstrate his hardline credentials and shore up dwindling political support over the bodies of Kosovo Albanians. But despite an indictment that spans 177 paragraphs and a prosecution pretrial brief that spans 714 pages, the existential threat faced by Kosovo Albanians at this time is barely mentioned. It was also noticeably and conspicuously absent from the SBO's opening statement yesterday. Massacres of Kosovo Albanians, such as that at Prikaz, were instead simply referred to yesterday as events. This implicit denial of the existence of the scale of criminality committed against Kosovo Albanians, while blaming those same KLA leaders for alleged crimes, is not an accident. We would suggest it's nothing more than prosecutorial gaslighting. Armed opposition by Kosovo Albanians to Serbian oppression did not spontaneously occur overnight, as if directed by a controlling mind, as the SBO would implicitly lead you to believe. Instead, after a decade of peaceful Kosovo Albanian opposition to the Serbian campaign of discrimination and harassment, had been roundly and studiously ignored by the international community, both at Dayton and beyond, there was a choice to be made. Would Kosovo Albanians continue the policy of peaceful opposition to Serb forces, or would they try a different approach? I would suggest that the choice of what to do when faced with oppression is best encapsulated by Victor Hugo in Les Miserables, as he describes the choice that has to be made by those facing oppression. Quotes, "So your desire is to do nothing. Well, you shall not have a week, a day, an hour free from oppression. You shall not be able to lift anything without agony. Every passing minute will make your muscles crack. What is feathers to others will be a rock to you. The simplest things will become difficult. Life will become monstrous about you. To come, to go, to breathe will be so many terrible tasks for you. Your lungs will feel like a 100-pound weight." Even those who had fully supported and subscribed to the policy of non-violent opposition to the Serb authorities led by the LDK came to realize in early 1998 that there was a point where a different approach was needed, even when that meant that people who had no military experience had to risk and often sacrifice their lives against the overwhelming Serb forces. This point was evidently the Ushari massacre on the 5th, 6th and 7th March 1998. Now, you have heard from Mr. Salimi how he joined the Ushari family in Prikaz and often stayed at Adam Ushari's house in the months and years before the massacre, but that by chance he was not in Prikaz on those fateful days. I remember seeing the massacre on the news in Prikaz 24 years ago, burning buildings filmed from the air, from afar, surrounded by hundreds of Serb forces. What those reports don't prepare you for is what it's actually like to visit the Ushari compound and walk through what is left of the charred rooms where the family members of Adam Ushari, including children as young as 5, sheltered from the constant shelling over those days. 59 people were murdered by those Serb forces over that 3-day period. You heard from Mr. Salimi that war was not a choice that he and his compatriots would ever have chosen had other ways of protecting themselves been reasonably available. Prekaz showed them that there was no other way. War was forced on them. Your Honours, the parallels with the current war in Ukraine are all too obvious. Faced with overbearing force only through their own courage, are Ukrainians able to defend themselves and their families from destruction? Teachers, doctors, accountants, waiters from all walks of life, with no military experience, have taken up arms to defend themselves and their people. Kosovo in March 1998 is eerily similar to Kiev in February 2022. Now, Your Honours, the core of the SBO case against Mr. Salimi, we say, is based on a fallacy. It is based on the fallacy that because the KLA was a resistance group in operation before the Yashari massacre, then it must automatically assume direct hierarchical control over the vast swathes of volunteers rushing into Kosovo from abroad, or otherwise taking up arms from within the country itself. This appears to be the heart of the SBO's case, that the central or general staff was pulling the strings and stood somehow behind every minute aspect, decision or action of anyone opposing the Serb forces in Kosovo. This is what the SBO, through Mr. Halling, attempted to demonstrate at length yesterday, although also confusingly suggested that the hierarchy which was central to the KLA from the beginning was also exercised flexibly, which appears to me to be somewhat of an oxymoron. Now, the SBO's theory in this regard is deceptively appealing in its simplicity, but Your Honours must resist adopting it, as it is universally and demonstrably wrong. Your Honours, we all know the tendency to romanticise the beginnings of a conflict and confuse what certain individuals wish had happened with what actually did happen. It is often said that victory has 1,000 fathers, but defeat is an orphan. This is never more true than in war. Any fighter memorialising their own deeds, or those of their units or their commanders, has a tendency to overemphasise or exaggerate their level of military success or organisation, while concurrently minimising their own failures or lack of organisation. The many documents that were relied upon yesterday by the SBO to demonstrate this supposed organisation epitomise this saying. At the very highest, they reflect the aspiration of individuals to organise themselves rather than the reality of facts on the ground. The same is true of those public statements that you saw, made in front of and for the benefit of video cameras, mere projections of a unified command, set forth to maintain faith in the KLA's struggle, and to bolster an image of the KLA as a well-structured organisation. It simply did not comport with reality. Mr. Whiting for the SBO spoke yesterday about the different puzzle pieces of the SBO case, which would come to Your Honours through different witnesses and via documents from a multitude of locations. The problem with trying to assemble puzzle pieces in this manner is that without a proper context or understanding of each piece and how it relates to the others, they often look deceptively similar, and one piece can be placed incorrectly far too easily. When this trial is over and the SPO sums up the case it has presented, these puzzle pieces will provide you only with a distorted and false final picture. Similarly, Mr. Whiting made reference yesterday to the supposed veil of secrecy that existed both during and after the war, which, according to the SBO, appears to make proving the structure of the KLA more difficult. However, what we would suggest is that Mr. Whiting, through his conspiratorial lens, sees as secrecy is actually simply the absence of evidence. The simplest answer is often the most accurate. The spontaneous uprising in Kosovo in March 1998, after the Yashari massacre, was not led and directed in an organised and hierarchical manner by Mr. Salimi and his co-accused, as the SBO would have you believe, but from a diaspora flocking into Albania and then Kosovo from all around Europe, often with no formal training, limited contemporaneous knowledge of the country they had come to defend, and few direct loyalties to any structure or hierarchy that they were supposed to be serving. These brave men and women, who came from all over Europe and even further afield, were simply united in their belief that the time had come to change tactics and pursue armed opposition. This realization did not translate into an acceptance that they would be fighting for the General Staff, or indeed even take orders from them as a matter of obligation. As the evidence of the SBO's own witnesses will reliably demonstrate, there was simply no organised structure to the groups that were formed in the spring of 1998, and no military hierarchy leading up to the General or Central Staff. Volunteers fought where they wanted, generally to protect their homes or families, and together with people they knew and trusted. Suggestions of where volunteers should serve were sometimes given, but with no concrete expectation that such suggestions would be followed. There were no consequences for individuals leaving the battlefield or returning to their home countries for weeks or months at a time. Uniforms, weapons, and supplies were sporadic at best. You've heard directly from Mr. Salimi moments ago about the creation of camouflage army pants, where different colours were painted on by hand on plain-coloured pants. Now, one only has to contrast the KLA with the might of the Yugoslav armed forces at the time, one of the largest ground armies in Europe, with an estimated 100,000 or so active personnel supported by 4 times as many, 400,000 reserves. Where the Serbs had planes, tanks and artillery, the KLA had rifles and homemade bombs. Where the Serbs had battle-hardened soldiers, brutalized by the killing fields of Bosnia and Croatia, the KLA had volunteers who had barely picked up a gun before. Where the Serbs had brigades, battalions and companies separated into a strict and well-organized hierarchy, the KLA had small groups of fighters coalescing around a village or a specific individual, hastily arranged into a community defense, where necessity, rather than careful military planning, pushed the pieces into place. Your Honours, this is the real context that the SBO doesn't want you to see. Ignore the balance between the Serb forces and the Kosovo-Albanian opposition. Ignore the hell that was happening all around, and ignore the confusion and chaos that was happening within Kosovo. And just look in the very specific areas that we want you to look at. Don't see the full picture. So what specific charges does the SBO want you to focus on? How did Mr. Salimi end up here, facing charges in 45 different locations over a period over 19 months? We suggest it's impossible to answer this question without examining the origins of the investigation carried out by the Swiss Senator Dick Marty over a decade ago, which ultimately led to the creation of the KSC. Now, as Your Honours well know and has been mentioned earlier, despite making sensationalist and false claims about organ trafficking, Senator Marty's eventual report actually also doesn't mention Mr. Salimi by name at all. But these spurious claims were used as the basis for continuing investigations against Mr. Salimi and his co-accused, supported, we say, by certain states who had a clear and direct interest in destabilising newly independent Kosovo. Now, although the allegations of organ trafficking were debunked, the investigations lasted for many years and eventually morphed into a duplication of investigations undertaken almost 2 decades ago by the ICTY, and more recently supplemented by those of UNMIK and ULEX in Kosovo. Indeed, perhaps Kosovo can have the dubious honour of being subject to more war crimes investigations than perhaps any other country and any other conflict in the world. Certainly, we suggest many more than Serbia, who managed to avoid subsequent extensive investigations into the conduct of their forces in Kosovo, despite the widespread findings of war crimes and crimes against humanity upheld by the ICTY in Milutinovic and Djordjevic. Now, after this investigation, the unfortunate perception is that such investigations are only successful if they lead to criminal prosecution. Otherwise, they are criticised as an expensive failure. Prosecutions, in turn, require courts. Courts, or ad hoc courts, may differ in their names. They may be extraordinary, special, or specialist. But unlike domestic criminal systems, they are set up with a specific purpose in mind: to prosecute specific individuals or a specific class of individuals. This was as true for the extraordinary chambers in Cambodia, responsible for trying senior leaders and those most responsible for crimes committed by the Khmer Rouge, as it was for the Special Tribunal for Lebanon, where the court was established to try those allegedly responsible for the murder of the former Lebanese Prime Minister. The same applies to the Kosovo Specialist Chambers, was set up to prosecute crimes which relate to the Marti report. Now, we suggest that the investigation that was carried out and conducted by the SITIF, the Special Investigative Task Force, and subsequently the SBO against Mr. Salimi and his co-accused, was never an impartial and independent investigation. Its purported search for truth was inexorably compromised from its genesis. A responsible prosecutor impartially and objectively assesses whether crimes have been committed, who physically perpetrated them, and then determines, based on the circumstances, whether criminal responsibility can then be genuinely and fairly imputed to others based on their own culpable conduct. Guilt must never be presupposed. If responsibility stops at the physical perpetrator, or in specific circumstances, even at their direct commander, that is normal. There can never be a presumption of guilt for war crimes or crimes against humanity that must always be transferred up the ladder. If such a presumption did exist, then every political or military leader in every conflict would face some criminal responsibility for crimes committed on the ground in such conflicts. The SPO started its investigation with the presumed guilt of Mr. Salimi and worked backwards to attempt to demonstrate how Mr. Salimi can possibly be linked to the various disparate underlying crimes it had identified. It assumed that as crimes were committed during the indictment period and that Mr. Salimi and his co-accused were in positions of authority in Kosovo during that time, they must inevitably have been responsible for those crimes. This has led to a case which is not simply weak, vague, poorly supported and ambiguous, but one which is fundamentally incoherent at its very core. Now, before even addressing the individual allegations against Mr. Salimi in this case, I just wish to focus briefly on two contextual elements which go to the heart of all charges in this case. And I'm aware that Mr. Mistic addressed similar issues earlier, so I will be brief. Mr. Salimi is charged with 10 counts of crimes against humanity and war crimes. If the SBO can't prove the fundamental contextual elements of either, then before this Kosovo court, a conviction cannot stand for those crimes. The SBO needs to prove, for crimes against humanity, the existence of a widespread and systematic attack against the civilian population. Now, it has often been said that insanity can be defined as doing the same thing over and over again and expecting different results. Yet this is exactly what the SBO appears to be doing in trying to prove the existence of a widespread and systematic attack by KLA forces during the indictment period. The ICTY had jurisdiction over Kosovo and investigated it thoroughly. No accused from the KLA was ever convicted of crimes against humanity. The same applies to cases of KLA fighters prosecuted by UNMIK and ULEX. Yet despite the reality, the SBO is trying again with the same allegations rehashed and repeated and hoping for a different result. The same applies to the civilian population at the heart of this case. Now, we heard the SPO attempt in earlier hearings and fail to explain the nature of the civilian population that is being targeted by this JCE in its retelling of the Kosovo War. If it cannot even explain its own case succinctly and clearly, how can it convince you of it? There is simply no coherent unifying factor for the disparate alleged crimes underpinning the charges against Mr. Salimi in the indictment. If such a factor did exist, the SBO would not have to perform mental gymnastics to be able to describe it. Now, these different contextual elements, the civilian population, the widespread and systematic attack, are not boxes to tick for the SBO. They are fundamental elements which serve to elevate crimes against humanity to the special category of international crimes to which they belong. It is a very high threshold that the SBO has to meet, and it must bring forth clear, definitive, and reliable evidence in support. It will simply not be able to do so. Similarly, the SBO also charges various underlying crimes against Mr. Salimi as war crimes. Yet, as the name suggests, war crimes need a war, and the SBO also needs to demonstrate the nexus between the underlying crimes and the armed conflict. It's not enough for the SBO, as it seems to want to do, to simply assert that there was an armed conflict throughout Kosovo for the whole of the indictment period, and simply expect your honours to accept that blanket assertion with no further detail. Each and every crime needs to be both committed during an armed conflict, which the SBO has the burden of proving, and sufficiently connected to it. We suggest that for substantial numbers of crimes alleged in the indictment, it can do neither. Now, assuming, however, that the SBO is somehow successful where others have tried and failed, and can therefore somehow prove the existence of underlying crimes and the appropriate contextual elements I've just mentioned, it must then, and most importantly in relation to Mr. Salimi, identify what his allegedly culpable actions are. This, we say, is where the SBO's problems really start. There are three different but overlapping forms of liability in the indictment: JCE, joint criminal enterprise, superior responsibility, and aiding and abetting. Now, at the outset, it is noted that the SBO has explicitly confirmed that there is no allegation in the indictment that Mr. Salimi physically committed crimes, as commission in their indictment is limited to JCE. In many ways, this is hardly surprising. If Mr. Salimi was actually charged as a physical perpetrator in this case, on the basis of the allegations in the indictment, the charges would not have got past the starting gate. Excuse me. Indeed, many of the allegations in the indictment stand out for their lack of inherent criminality. Prosecuting Mr. Salimi for questioning an individual, returning ID cards, or even purportedly threatening a journalist would almost be absurd if the potential consequences for Mr. Salimi were not so serious. Even on the SBO's case, where Mr. Salimi was allegedly present or informed that individuals were being detained or interrogated by the KLA, which the defence disputes, the SBO's own witnesses are expected to testify that whoever they thought was Mr. Salimi actually instructed those guards to either release the person concerned or allow them to join the KLA. Suggestions that were conspicuously ignored by those to whom they were addressed. Indeed, this last point fundamentally calls into question the SBO's case in relation to effective control if directions can be so routinely ignored without hesitation or consequence. But the defence recognises that there is one serious and direct allegation against Mr. Salimi, namely that an individual was beaten in April 1999 in Klečka by a masked individual, and that the SBO's case is that this person was Mr. Salimi. Now, Mr. Salimi categorically denies this allegation, which incidentally was hidden from the defence until a few months ago. When I say hidden, I mean it was redacted from the indictment and was only made aware, we were only made aware of it on the 27th of January. But even on the prosecution's case. There is a lack of direct identification evidence. It's entirely predicated on supposed references to the nickname of the individual by other soldiers present, a convenient and distinctly weak basis for such a serious charge, with no corroboration. So instead of seeking to prosecute Mr. Salimi as a physical perpetrator, the SBO relies exclusively, almost, on joint criminal enterprise and superior responsibility, dictated not, we say, by evidence, but by subjective prosecutorial discretion. Now, while Mr. Salimi is also charged with aiding and abetting the crimes in the indictment based on the same allegations as are put forward for JCE, this appears to be barely more than an afterthought by the prosecution, comprising one generic paragraph in the indictment. JCE and command responsibility are well known before international courts. When used objectively and responsibly, they are potentially able to capture the full level of criminality for international crimes, not just those acts of physical perpetrators, but also those in higher positions, supposedly who bore greater responsibility for them. This is the purpose for which they were created. For example, instead of prosecuting only a lower-level physical perpetrator, these modes of liability allow for a prosecution of a person who was supposedly directing that individual. But there's no allegation in the indictment that Mr. Salimi ordered any crimes, nor that his acts or omissions somehow instigated crimes, or even that he planned them. Instead, the allegations are far more prosaic. It's alleged that Mr. Salimi took part in negotiations with internationals and other Kosovo or Albanian armed and political groups in Kosovo and Albania. It's alleged that Mr. Salimi oversaw the delineation of zone boundaries. It's also alleged that he coordinated and received reports about and took part in military operations. Now, reading these allegations, anyone would be forgiven for scratching their head. Where exactly is the criminality in any of those? What has the SBO suddenly found in these actions to justify the indictment of Mr. Salimi and the deprivation of his liberty for well over 2 years already, with an SBO case that will last at least 2 more years? What has somehow escaped his predecessors over the last 2 decades? And what has actually happened is that each and every one of Mr. Salimi's acts and omissions, however minor, however tangential, which are neither criminal in themselves, nor otherwise have any causal impact on the underlying crimes alleged by the SBO, are aggregated to try and demonstrate some culpable conduct on his part. Everyone knows the principle that if you throw enough mud at a wall, some of it will stick. In this case, the SBO is throwing everything at Mr. Salimi, whether inside the temporal scope or outside it, the temporal scope of the indictment, or well after it, in the vain hope that enough of it will stick to the JCE it has constructed and will somehow sweep Mr. Salimi along with it. But this is the inherent problem with JCE and superior responsibility, where the motivation to construct a case against a particular individual is so strong, as it seems to be for the SBO in this case against Mr. Salimi, these forms of liability can be stretched well beyond their natural limits, at least to the extent of confirming an indictment on the basis of these allegations. However the SBO seeks to mix and match the different allegations against Mr. Salimi, the evidence simply does not demonstrate that he contributed to a supposedly common criminal plan, even if it assumed that a common criminal plan existed, which the defence strongly disputes. Indeed, it's not just the contribution of Mr. Salimi to the JCE, but indeed the alleged criminal plan itself at the heart of the JCE, which is a prime example of the flawed approach of the SBO. Now, we know from the indictment that the SBO charges that at least between March 98 through September 99, the 4 accused and other members of the JCE shared the common purpose to gain and exercise control over all of Kosovo by means including unlawfully intimidating, mistreating, committing violence against, and removing those deemed to be opponents. Was the purpose to gain and exercise control over all of Kosovo inherently criminal? No. That purpose in and of itself is not. It was entirely legitimate and indeed supported, we would suggest, by vast swathes of the international community for Kosovo, especially in light of what had happened across the former Yugoslavia in the preceding decade. The protection of Kosovo Albanians from Serb atrocities and the consequential liberation of Kosovo is why NATO went to war with Serbia in support of the KLA. Instead, because the objective of liberating Kosovo somehow allegedly involved crimes committed by others, not by Mr. Salimi, he is alleged to be a part of the JCE in relation to those crimes. Yet no one is suggesting that these crimes were somehow necessary to liberate Kosovo. The SPO has simply looked back over the course of this entire 2-year period, assessed that some crimes were submitted by KLA forces in the process of liberation, and placed all of those firmly at the door of Mr. Salimi and his co-accused as being the face of the KLA. In this regard, the SPO's submissions yesterday on the motive behind the alleged JCE were illuminating. Now, despite telling the court the motive was not required to be shown by the SPO, Mr. Whiting took the opportunity to suggest that it could have been to win power, could have been due to fear, hatred, or even revenge. But it didn't matter, because motive was neither an element of the offence or a defence. Subsequently, each prosecutor in turn proceeded to suggest that the next would inform the panel about exactly what this true purpose and motive was. But at the end of the entire prosecution opening statement, none had actually done so. Without an articulated, logical and clear motive that unifies the disparate accused, the incoherence of the SPO's JCE theory is laid bare. Indeed, the absence of this the absence of this motive stretches the concept of JCE liability so far as to undermine its very purpose, and indeed, we suggest, calls into question the entire basis of the case against Mr. Salimi. The same concerns apply to the application of superior responsibility, a form of liability, as you well know, originally conceived to punish the Japanese military governor of occupied Philippines, commanding one of the most strictly hierarchical armies in the world, for a litany of crimes committed by men under his command, including resulting in the deaths of 25,000 men, women, and children. But in this case, the same principle has been pulled and expanded to ascribe liability over a collection of isolated and sporadic incidents committed, if at all, by individuals who did not see themselves and simply were not under the control, the effective control of Mr. Salimi, or indeed any of the other accused in this case. Now, furthering this theme of expanding superior responsibility beyond its natural limits, the SPO has even recently now asserted that each accused somehow fluctuated between being an effective subordinate of their co-accused to being in command and control of that co-accused, swapping between such positions at will. No doubt, as the evidence is presented, which position they take will be conditional on whichever suits the prosecution case at any given time. As will become clear from the SPO's own witnesses, the structure and hierarchy necessary to ground proof of effective control over subordinates simply did not exist in this case. Indeed, in a moment of welcome candour, the SPO recently admitted that one of the reasons it needs so long, 2 years, to present its case, was due to an absence of good evidence on the structure of the KLA by comparison with the clear and consistent evidence they had in relation to the atrocities committed by Serb forces in Bosnia. In other cases, they had previously prosecuted before the ICTY. The mask slips, if only for an instant. Sometimes, as we expect this case to demonstrate, the absence of good evidence to support a particular allegation is a pretty good indication that the allegation is in fact unsubstantiated. Lack of coherent and consistent evidence on the existence of the KLA structure serves to demonstrate that there was no structure. Lack of evidence of a common criminal plan dictates that no plan existed. It is not more complicated than that. If the SBO had investigated this case objectively and impartially, rather than with a specific purpose to target and punish Mr. Salimi and his co-accused, they would have reviewed the evidence, decided that whatever underlying crimes had been committed, and decided that whatever underlying crimes had been committed, there is simply no case directly against Mr. Salimi. He is bearing the consequences of the SBO's refusal to follow that central principle. To conclude, Your Honours, I've spoken today about the SBO's case against Mr. Salimi, against which he must defend himself. From having surrendered early to the police station on the day of his arrest in November 2020, when he was informed of the arrest warrant against him, to his statement in court earlier today, Mr. Salimi has fully engaged in this criminal process, despite the inevitable strain of being detained in a foreign country, away from his home, away from his family, and away from the country that he fought to liberate. He has attended every hearing, either in person or remotely, and fully intends to continue to do so throughout the presentation of the SBO's case. As we are confident the evidence will bear out over the next 2 years, if any of the crimes set out in the indictment period did actually occur, they were isolated and random crimes against individuals which sadly occur in any conflict, and Mr. Salimi simply has no connection to them. Those responsible are at most the physical perpetrators or those individuals who were directly responsible for ordering any of these crimes. Simply put, crimes that are committed in war do not have to be the result of a plan or policy, even if relatively numerous. Mr. Salimi, Your Honours, is responsible neither as a perpetrator, as a member of a JCE, as a superior, or as an aider and abettor of any of the crimes set out in the indictment, and I'm confident that the evidence presented in this case will demonstrate this fact to the full. Thank you for your attention.
Thank you, Mr. Roberts. Before we adjourn, I want to correct yesterday's record as regards the date of the further appearances of the accused before the pretrial judge. It was my mistake. Instead of 5 October 2022, the record should reflect that the further appearances of each of the accused took place on 10 May 2022. So this concludes today's public hearing. We will resume tomorrow morning at 9 o'clock to continue with the opening statement of the Krasniqi defense. I thank the parties and the registry for their attendance. I also wish to thank the interpreters, stenographers, audiovisual technicians, and security personnel for their assistance. This hearing is adjourned.
All rise.